Right. Judge Rogers, may I open court?
Yes.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5302, TikTok Inc. and ByteDance Limited versus Donald J. Trump, official capacity as President of the United States et al., appellants. Mr. Byron for the appellants, Ms. Brinkman for the appellees.
Good morning.
Good morning, Your Honor. May it please the court, Thomas Byron from the Department of Justice, here for the government defendants who are appellants in this case. The district court's injunction here misunderstands the scope of IEPA's exceptions in Section 1702B, and plaintiffs' interpretation of the language in that provision concerning indirectly regulating or prohibiting conduct would have no limits at all and is directly contrary to this court's precedent in Walsh against Brady. In that case, this court rejected a similarly broad argument that a substantial burden on importation of informational materials would be a prohibited indirect regulation of that conduct. The district court's preliminary injunction here can't be squared with that precedent. Regulation of activity on a mobile app is not the equivalent of regulation of the mobile app's availability on an app store, which is the only prohibition at issue here, is not the equivalent of regulating directly or indirectly the activity of users on that app or the platform it serves. Here, the prohibitions imposed by the Secretary of Commerce and the President regulate only the commercial transactions that make a particular mobile app available within the United States. They do not target in any way the conduct, the protected activity of the users on the TikTok platform, who are able to import and export information or informational materials or exchange personal communications using either that platform, for example, on a web browser, or other platforms that are also available to them. The fact that the activity of the users is unconstrained by the commercial prohibition at issue here is dispositive. It's not enough that there might be an incidental effect, as the plaintiffs argue, that might...
They don't argue incidental effect, they argue indirect regulation. And it seems to me, at least me personally, that deciding what indirect regulation of informational materials means is critical to this case. And Walsh seems less helpful because that was a ban on travel, and it just happened in that instance to affect someone who wanted to travel to import. But that was sort of a one-off or unusual consequence of the regulation. Lots of travel wasn't going to be to import informational materials. But here we have for purposes of this stage, a prohibition on people joining an informational community that TikTok has created. And so all the time, it's not going to be one-off that it affects people's speech. On the other hand, as you have argued, TikTok is quite clear that they are just a platform, and at least have not argued here that their own speech is what is at stake. And so I'm trying to figure out what the government's definition, not of incidental, but of indirect regulation is. What would be an indirect regulation of speech? And if you can give me an example in the sort of social media concept environment, that would be most helpful.
Sure, Judge Millett. So let me start, if I may, by going back to Walsh itself, which made clear that it was an indirect regulation of importing posters from Cuba when the government required any payment for those posters to be put in a blocked account and prevented the seller from accessing it. That was what this court identified there as indirectly regulating, and what the court thought that Congress was principally concerned about. So translating that to this context is obviously going to be imperfect. Congress had nothing like this in mind, obviously, as plaintiff's brief itself points out. We would say, however, that there are examples of indirect regulation that effectively prohibit all importation or exportation of informational materials. And that's what would make them like the blocked account example in Walsh. So, for example, you could imagine a prohibition imposed by the government. It would obviously be a direct regulation, just to start there, Your Honor, if the government said no importation or exportation of videos to China. That would be the kind of direct regulation prohibited by 1702B. It would be an indirect regulation, for example, if the government said not to users, importers or exporters, Americans, but instead to all internet service providers, ISPs. If the government said to every ISP operating in the United States, you must prohibit the transmission of any video to a Chinese IP address. That, it seems to me, would be an indirect regulation. But what's going on here is quite different, because it's a regulation instead of a particular platform, leaving available alternatives. So just as in Walsh, where the plaintiff wanted to travel.
It's not just a platform. Let's just assume, sake of this point, just so I understand your indirect example, let's assume that what the government were regulating was the number one platform for importing or exporting videos between China and the United States. Just assume, I'm not saying that is, but let's assume we're dealing with that platform, whatever we want to, platform Q. And it is responsible for 85% of all imported and exported videos from China. And the government said that platform is shut down. Would that be an indirect regulation at that point because of the volume?
No, Judge Millett, it wouldn't. And the reason is because by engaging in a business that permits Americans to undertake protected activity, a company or a foreign government doesn't insulate itself from regulation concerning national security. In other words,
if my hypothetical were 100%, your answer would be the same.
The same answer, Judge Millett. Let me back up for a moment and just say this.
Like the ISP providers then. So that transports, that allows the interchange of information. But go ahead.
So Judge Millett, I think the same answer if alternative means remain available. So I think that the question then becomes, is there a practical imposition of what amounts to a prohibition? That's what the court in Walsh said effectively, I think, was true of the blocked account requirement that was an indirect regulation there. But it's not enough that a particular preferred method of importing or exporting informational materials might be burdened. That's what the court said in Walsh. The plaintiff there wanted to travel.
If that method, it depends, a lot depends on what you mean by alternatives. If the alternatives to my platform Q, which we'll say for entertainment purposes was 95% of the interchange between China and the United States with videos. And it's 95% because platform Q is incredibly good. And it has all these kinds of features and allows people to form communities and to conjoin videos and communications in a way that the other platforms, which are all grainy and have very poor editing techniques, do not. And so there's alternatives in that sense, but they simply do not allow the same type of interchange and intercommunication that platform Q does.
So Judge Millett, first of all, I think it's hard to measure those kinds of comparative qualities. But here, I think the answer is revealed in the plaintiff's own evidence.
I'm just trying really to understand. your legal definition of indirect, are you saying that if the other alternatives are just really not that good and don't, yes, you can exchange videos, but you can't have the same type of communications and interchanges and quality of speech, and it's an enormous percentage, 95, pick it up, whatever high number you want, 95%. That would be indirect regulation, but we don't need to worry about it here because the facts are different, or that would not be indirect regulation regardless of the facts in this case.
So first of all, Judge Millett, it would not be indirect regulation because it wouldn't prohibit effectively.
Okay, but your alternatives there really are not allowing the same type of speech.
Well, and that's why I think the first part of your proposed distinction is relevant as well. And that's what I was getting at, if I may just continue to answer your question, with the fact that the plaintiffs here put in evidence in support of their request for a preliminary injunction, demonstrating that there really were effective alternatives and that was their business concern, was that users would migrate to those alternative platforms and wouldn't come back to this one, even if it were later made available.
No, I understand that. So you're saying that quality of the alternatives, the comparability of the alternatives does or does not matter to indirect regulation?
So I think it might matter, Judge Millett, in some circumstances, but that question isn't.
What is the legal test? We have to articulate a test, and I don't see anything as helpful maybe as you do in Walsh. What would you say in an indirect regulation?
So I think the language of Walsh is relevant, Judge Millett. It says, until 1988, the regulations nominally allowed the importation, but in reality banned it by requiring that the importers make payment into blocked U.S. accounts. So if in reality it would be a ban, then that would be an indirect regulation by the language of this court's decision. So perhaps, Judge Millett.
I'm sorry, go ahead.
No, I guess what I was trying to get at is that to the extent we're trying to understand the lesson of Walsh and the scope of the precedent that this court has decided, if you're asking, would a ban on what is a far better means be an indirect ban, in reality a ban in the language of this court? I think that's potentially a hard question, but one that you need not answer here because the plaintiff's own evidence demonstrates that it's not true.
But to the extent far better then does factor into your definition, even if it's not a total ban.
Not our definition, Your Honor. I'm trying to answer your hypothetical. In other words, I think in reality banned is the definition this court has offered. And the question then becomes, well, is it in reality a ban if there is a preferred alternative that really is so much better? I don't know the answer to that.
In effect, ban means that whatever was regulated was just a facade, and that this really is direct regulation by another name. That seems a fairly narrow definition of indirect regulation.
Well, in reality banned is what the court said, and I think that's a meaning. It gives meaning to indirectly regulate, Your Honor.
So a de facto ban.
Yes, I think that's what the court was getting at.
That's it. Anything short of that. Either you tell me we don't need to decide. If you're telling me I don't need to decide it in this case, then it sounds like the test is de facto ban plus something else, but you don't need to decide it in this case. But other times it sounds to me like you're saying the government's position is de facto ban, and that's what I'm trying to sort out right now. Is it de facto ban or is it de facto ban plus?
It's de facto ban, Judge Millett.
Okay, so that it doesn't matter about the facts of this case.
I think it doesn't matter to the extent that you might be concerned about a harder case where you think it might matter. That's what I don't think this court needs to decide in the context of the preliminary injunction.
This one bans by forbidding new users from joining. This prohibition bans a lot of Americans from joining the communications and exchanges that I think more than a quarter of the American population is already engaged in. For all those people who wish to join in those communications, they're banned once they can no longer download the app. How are they not banned?
Judge Millett, they're not banned for two reasons. First of all, the President's executive order and the Secretary's decision memo make clear that the particular most significant risk here is from the mobile app itself, not from the platform as a whole, and that other means of accessing the platform remain available. So, for example, a web browser can access the TikTok platform without posing the same national security risks. Similarly,
people don't have to sign away licenses and they don't give up their personal data if they go in through their web browser?
It depends, Judge Millett. Yet so the record here does not investigate in great depth, but it is true that one can use a web browser without establishing an account on TikTok. And establishing an account is where much of that personally identifiable information is.
Where is this? Is it in your brief or is this in the record somewhere? Because I had not heard.
It's not, and that's what I said a moment ago. The record here does not identify those details, but what it does identify is
your brief that they can go in through the web browser, that is allowed?
I believe we did mention that, Your Honor. Yes.
All right, but they can't set up an account.
They don't. Well, Your Honor, I don't think we addressed that question, but you asked, and I'm trying to answer.
So the answer is you cannot set up an account that way, or you can get in without setting up an account.
That is my understanding, Judge Millett, and if that's relevant to the court's determination, we can certainly address that in a supplemental file.
But can you set up an account if you go in through a web browser?
Yes, Judge Millett, I believe you could.
And you would have the exact same concerns.
Not the exact same concerns, no, Judge Millett. So, for example, the geolocation data associated with a cell phone or other mobile device is a significant privacy concern and includes a vast array of sensitive personal information at stake here. Similarly, collecting clipboard data, which is available and has been done from mobile devices, is not demonstrated to be true elsewhere. So, and I'll just point to the Supreme Court's decision in Carpenter to emphasize that geolocation privacy concern, where that might not be present in other means.
Is that the national security? I mean, that did not seem to be the chief national security concern.
It is part of it, Judge Millett. So it's mentioned in the Secretary's decision memo, and I can find the page for you if you like. The fact is there is a wide swath of data that's collected by the TikTok mobile app that the President and the Secretary identified as permitting the Chinese government and the Communist Party of China to collect information on Americans and compile vast databases that pose a threat to the security, the economy of the United States.
If these same videos were getting shipped back and forth between the United States, the exact same videos on CDs instead of on this app, you would agree you couldn't ban that, right?
Correct, Judge Mudd, and we are not banning the sending of the videos.
Aren't you then, because the statute says regardless, informational materials regardless of medium. And what you're doing is you're taking those exact same videos, and because they're not on CDs, but they're instead on this medium, the TikTok mobile app, because of the medium, you say you can ban them. That's another thing I'm having trouble with.
Right, Judge Mudd, but I'll point out that the concern here is related to how the TikTok mobile app collects information about users.
No, I understand. I'm just with the language at 1702 B3. If you agree that these same people, users, could, if they wanted to go back to my old antiquated era, could exchange these things back and forth on these videos on CDs. But what bothers the United States is the medium of transmission, use of a mobile app rather than a CD. It's banned. And that seems to be a problem, because the B3 says you cannot prohibit the import or export of informational materials, which I'm going to assume you agree that these videos are, regardless of the medium of transmission. It seems to me you're making a difference based on the medium of transmission, whether it's CDs, whether it's through a web browser, or through a mobile app. How is that not distinguishing the same materials on the basis of the medium of transmission?
So it does regulate the medium of transmission, Judge Meyer.
No, how is it?
Essential.
I'm sorry, go ahead. Please go ahead.
Well, no, I think that's essential, because I think by including that additional language in the provision in 1702 B3, Congress recognized that there may be that there is a difference between regulating the transmission of the materials on the one hand and regulating the medium on the other hand. And it is the transmission, I'm sorry, not the transmission, it's the importation or exportation of those informational materials that Congress sought to protect. And so it may be, Judge Millett, in a particular circumstance, I'm gonna offer a crazy hypothetical, if it were demonstrated that fingerprints would always be present on a CD, and that the collection of those fingerprints by a foreign adversary, a foreign government, posed a threat to national security, that perhaps it would be permissible to regulate the transmission of videos by CDs, but permit it by other means of, by another medium of transmission. It would not be, in reality, a ban of the importation or exportation, as the court said in Walsh, to do so. So the distinction between user activity on the app and regulation of the app itself is the key distinction here that we think demonstrates this is not an indirect regulation of user activity.
Well, let me just ask you then, what do you understand the sub 3 paragraph to be addressing? Because it is following the does not phrase. In other words, I thought in your brief you were arguing in part that all you're seeking to do is to regulate in one form or another business to business transaction. You're going to sell the company, that type of thing, not affecting me and how I get information or what medium I use to get that information.
Judge Rogers, I take it you're asking about 1702b3, the exception in IEPA for importation or exportation of information or informational materials. Do I understand that correctly?
That's what we've been talking about for the last 5 minutes.
Yes, that's right, Judge Rogers. And so I think that the distinction I just was discussing with Judge Millett, I would emphasize here as well, that regulating the business of the TikTok mobile app is distinct from regulating the conduct, the protected activity of users on that platform. So whereas a user can still send videos using other means, the government is free to prohibit the business activities that support the mobile app that poses a national security risk. That's the key distinction, Your Honor.
Even given the language? I'm just trying to understand what Congress had in mind when it wrote this language. It's saying the president can't do this.
Correct, Your Honor. But what it says the president can't do is regulate or prohibit directly or indirectly importation or exportation of information or informational materials. And Walsh says that it's a regulation indirectly if it's in reality a ban on the importation or exportation. That's a far greater standard, a higher standard than merely regulation of a preferred method of importing or exporting informational materials. So just as the plaintiff in Walsh wanted to travel because that was the preferred method he wanted to negotiate the importation of Cuban posters, just because users here want to use the mobile app as a means to send their videos, doesn't mean that it's an indirect regulation by the government of sending videos to prohibit the mobile app from operating in this country.
I know you say it, but Congress wrote this language. It seems to just fly in the face of that. But I don't see Walsh to control here.
Judge Rogers, I think Walsh does control. And let me offer another perspective on.
It doesn't control in the sense that the holding is on all fours with the issue that's here. There may be language in it that you're using to elaborate on your reasoning, but that's different.
Judge Rogers, I don't think it's just that. The holding in Walsh specifically rejected the kind of broad interpretation of indirectly regulate that the plaintiffs here have offered and the district court relied on. In that sense, we think it is controlling and that the district court's injunction cannot be squared with this court's decision. The plaintiff in Walsh said that anything that is a substantial burden on importation or exportation of informational materials is indirect regulation. This court's holding rejected that argument. The plaintiffs here argue anything that prevents the use of a particular preferred platform or burdens the use of that platform is an indirect regulation. That is inconsistent with Walsh's holding, Judge Rogers. And we would just emphasize that there's nothing to indicate that
I just wanted to follow up on, if there were no other apps that allowed video sharing like this, the only other way to share videos would be by mailing CDs back and forth or tapes back and forth between the United States and China. Would that count as an alternative?
Yes, Judge Millett, it absolutely would.
So if you banned every video sharing app, and for security reasons, you have the same security concerns, this is my hypothetical, every video sharing app that uses the internet, they're all banned so that people are back to snail mail CDs if they can buy them. I'm assuming they can, so it's an alternative. That would not be an indirect regulation of speech in the government's view.
It would not be a ban in reality of importing or exporting.
It would not be an indirect regulation of speech or of informational materials being exported or imported.
That's right, Your Honor.
Okay.
But I would also emphasize, Judge Millett, that the language adopted in the Second Amendment in 1994, the Free Trade and Ideas Act, did identify a broadening of 1702b3, and it did so in a way that recognized that intangible informational material was also protected. But that intangible informational material is the video. It's not the means of transmission by on a particular platform or in a particular medium. That's why it's important that Congress nevertheless maintained that regardless of format or medium of transmission, distinguishing between the information that a user seeks to import or export on the one hand, and the means that they seek to do so on the other. As long as it's not in reality a ban on the import or export, it's not an indirect regulation of that activity.
Well, the language also talks about regulate indirectly too. So we've been talking a lot about prohibitions and bans. So what's an example of an indirect regulation?
Your Honor, I think that, for example, we spoke earlier about the hypothetical I suggested where, because the government cannot directly prohibit something, it can't require a private company to prohibit something either. If it's an altogether sweeping prohibition, leaving no alternatives. So similarly, if the government can't regulate by, I'm having trouble imagining what the kinds of regulations we might have are, but let's say requiring registration of every video sent to China. That might be a regulation, one might imagine. Requiring every user to register with the government. So that would be a direct regulation. It can't require every ISP, using the example we spoke of earlier, to maintain a list of every user's video sent or received to or from China. I could imagine that being an example of indirect regulation. But here the key too is that it would regulate all imports and exports of the informational materials, not just a particular method or platform that some users might prefer. And that's the key distinction that we are emphasizing. And the reason this is important, Judge Millett, is that Congress did not intend to allow a foreign adversary to evade regulation of conduct that threatens our national security merely by engaging in a business or offering a platform that American users might prefer to use in some circumstances to export or import information. That would be a significant undermining. It would, as this court in Walsh said, allow the foreign adversary to sap the power of the regulatory scheme here. And that's what the plaintiffs are urging. And we would ask this court to reject it.
Before you leave us, are you mean deference, Chevron deference or something like it to your interpretation? Because the most I got out of your brief was, speaking of indirect, backing into, here's a case where that court decided.
Yes, sure.
The government's interpretation gets deference. But I never heard you say the government claims deference.
We're not seeking deference with respect to anything in the Commerce Secretary's decision, Judge Millett, but I will point out that we have cited, for example, to a Treasury Department OFAC regulation that has been, and those regulations have been recognized by this court and others, Third Circuit, Second Circuit, I believe, as worthy of Chevron deference. And we've pointed to that as an example of—
Is that the regulation that says it doesn't apply to materials that were not in existence at the time?
That's right, Judge Millett, yes.
Your position, but that's trying to figure out how that fits onto this.
So
you wouldn't even allow, even if the videos already existed at the time, someone doesn't get to sign up for TikTok because they say, I only want to ship out, only want to communicate with videos that are things I've already made. So I couldn't figure out what the connection was.
So Judge Millett, the key here is that every time a user uploads a video onto TikTok, it creates a new and unique communication. And in that respect, it is subject to that distinction. That's not something we're emphasizing. You asked about Chevron deference, and I was merely pointing out that that's an example where there has been Chevron deference that we did point to. We are not asking for Chevron deference with respect to the Commerce Secretary's decision.
And my colleague's indulgence, I just have one question about B1. Personal communication which does not involve a transfer of anything of value. Value to whom? To TikTok, to the speaker, to the listener, all of the above, any of the above?
I think any of the above, but in this case, it's all of the above, Judge Millett. So the easiest example of this in the terms of service is the license that TikTok compels every user to grant to TikTok itself over any communication or any video or any other activity on the app. That is indisputably a thing of value transferred from the user to TikTok as part of the communication or transfer of information. And there's no question there that the license is a thing of value. But TikTok has also monetized the activity of users on the app in a way that is quite different from the examples of the Postal Service or a telephone company. And so we think that even by that measure, it is a thing of value to everyone involved, the way that TikTok has extracted value from user activity in this sense. And that itself demonstrates some of the concerns that the government has identified about the sweeping collection of sensitive personal data here.
Thank you.
Why don't we hear from counsel for appellees?
Thank you.
Thank you, Your Honor. May it please the court, Beth Brinkman for the plaintiff appellees. The Commerce Department's prohibition would restrict a robust community of millions of Americans sharing personal communications and informational materials on the TikTok app. That prohibition violates Congress's explicit limitations on IEPA authority. The government's argument that the prohibition regulates a business-to-business transaction doesn't change that fact. A government prohibition can regulate more than one thing. Congress specified here that IEPA does not authorize indirect regulation. That means the government cannot choose to restrict communication by choosing an indirect means to do so. There may be close cases, but this is not one of them. The prohibition stops US users from exchanging videos, photos, art, audios, text, political messages, and it was designed to do just that. I wanted to take a moment and turn to the Walsh case, as was discussed at length, and what indirect regulation means. The Walsh case and analysis wholly supports the plaintiff's position here. The regulations there allowed posters to be imported. There was no stopping that. The additional point was whether or not a regulation could restrict travel to Cuba. And the court held it could be because it was only tangential to the importing of the posters. Indeed, a full examination of that opinion indicates that even all travel wasn't prevented. What was traveled was that you could not pay for it. Somebody could have even traveled to Cuba to do that if the host paid for that travel. That was not an indirect regulation, import of the posters. By contrast, the example that opposing counsel spoke about buying posters, allowing the buying of posters, but then saying that it had to be paid for into an account that the government then blocked, that was not prohibited. That's in fact what existed before the 1988 amendment. And that's why this court discussed it in the Walsh case. It's exactly that type of situation which we find here. The government tries to say, oh, you know, we're not doing anything about these communications. We're just not going to let you have the app to do it. That's exactly what the indirect regulation was that the court in Walsh said was not permissible.
Right, can you repeat that sentence one more time? I want to make sure I heard that.
Certainly. In the Walsh case, the court explained what was an indirect regulation that was not allowed.
We have exactly that here
because here, the government tries to say, oh, we're not regulating the videos or the messages. But in fact, go ahead, you know, and try to use them, you know, try and buy the posters, but your money is going to go into an account and oops, we blocked the account. Here, we'll try and use it. Oops, you know, the app isn't available. That is exactly what's happening here is indirect regulation. The idea that there could be some kind of alternatives that would satisfy this, I just would want to say several things. First of all, the TikTok app cannot be replaced. There's no adequate or comparable alternative. The features on the TikTok app, there's a duet feature, a stitch feature. They're creative, they're clever. I mean, that is why it's so successful. So there isn't some kind of adequate replacement for that. Moreover,
that sounds like a complicated factual question, whether they're, I'm sure TikTok is of the view that it is absolutely the best, and it's obviously incredibly popular. But for purposes of a preliminary injunction, it's a little hard to rely on that factual assertion when at the same time TikTok is saying, if we're banned, people are going to leave in droves to these other apps and will not come back. If TikTok were that special and had all these extra features, folks would come back. And so I find it a little hard at this stage to rely on the uniqueness of TikTok. Tell me why I should.
Well, we don't think you need to, Your Honor. I would say, first of all, you know, when communities leave, it's difficult to come back, not because you're not the best product, but they've transferred all of the, you know, opportunity costs that have passed. So I don't think that goes to anything about the quality of the uniqueness. I would also say, though, it's not in the statute. It doesn't say so long as you can do it some other way. There's nothing like that in the statute. This is about the text of 1702B, and it's not in the statute. And just to give an example, to try and say that's not indirectly regulating the messages, if there were a large newspaper and the government said, you know, you have a lot of editorial writers, you have a lot of subscribers, you don't need any more. You know, we're just going to say no more. You can keep doing what you have, but no more writers, no more subscribers. I mean, this unquestionably would be indirect regulation of those messages. And again, there may be line drawing, but this is not a case where that's required.
But the government is saying that we can draw a line because the government is saying that people can still use TikTok, and new users can still use TikTok. They just can't use it on the mobile app. And so they're not really regulating the use of TikTok. They're regulating or the information. They're regulating just the mobile app.
Your Honor, the suggestion that they're just regulating the mobile app, the just is incorrect, because although they're regulating the mobile app, they're also indirectly regulating the videos, the audios on there. And if I could point the court to a couple of things. I mean, we're talking about what the agency did here. Under the Chenery Doctrine, we looked at what the agency relied on. And the district court here found both the purpose and effect of this regulation was to indirectly regulate that content, those videos. And I would direct the court to a couple pages. It's throughout the Commerce Department's memorandum about what they are regulating here. But there's one on page 323 of the joint appendix. This is where under a section called vulnerability, and the Commerce Department is talking about the vulnerability they perceive, and there are 8 listed categories. And I just want to focus on number 3. This is a quote. They're talking about what's collected and what poses the vulnerability. Quote, user-generated content, including comments, photographs, videos, etc. That is what's being regulated here. And again, back on page 332 of the joint appendix, the Commerce Department talks about preventing collection and aggregation of data, also about its transmission. That is what is being regulated, what it was intended to, and what it does. And that is
where
what,
are you on 332? Which paragraph?
Pardon me?
Paragraph on 332?
On 332, it's the second full paragraph, Your Honor, belonging the below prohibitions. It talks about, denying access, reducing functionality, and then it goes on, and it talks with the objective of preventing collection, transmission, and aggregation. And again, back on page 323, Your Honor, it's in the first full paragraph under the heading vulnerability, and the subheading, there are 8 lists there. 3, user-generated content, including comments, photographs, videos, and virtual items.
If somebody opens a TikTok account on their web browser instead of on, I guess, the mobile app, which of these 8 categories of information would no longer be implicated? To the extent they want to distinguish mobile app and web browser, I would have thought almost all of this would be the same.
Yeah, I don't know what their distinguishing is, to be quite honest, Your Honor, I don't. Certainly, user number 3, when you're looking at the user-generated content, I don't see how there would be any distinction, including comments, photographs, videos.
I assume registration and profile information, payment information.
So much of it.
Phone and social network contacts, I assume would those still be available or not?
I mean, I'd really have to look, Your Honor, but I'm sure a vast majority of it would be. The government has made no attempt to distinguish that in the record. Indeed, again, because we're looking at agency action under the Chenery Doctrine, we're not looking to what, the government may be theorizing in a brief, but what the agency actually did here. So
well, do you challenge the finding by the government that the collection of this sort of data from by a foreign power presents a national security, a valid national security concern?
This requires no second guessing of the national security determination here for several reasons, Your Honor. Judge Nichols looked directly at that and indicated this was a question of statutory construction, not second guessing that. He also looked at on its face at the Commerce Department's rationale and pointed out that what the Commerce Department speaks about is the country of China, and then says could possibly, maybe at some point in the future, there might be something not talking about the plaintiff. That's right on its face. Also, that kind of basis in the record, I would say also, we have other challenges remaining in this case, and it relies on very inadequate and outdated information. That is part of our due process and APA claim. I would also say the timing of the government's action itself undermines on its face again the national security urgency that would, at all be affected by this preliminary injunction. And we go through in our papers kind of the delay over periods of times of issuing these. I would also say that, again, on its face, this first prohibition doesn't allow security updates, which is just counterfactual to the claim that they state, again, just on its face. And the last thing I would say, Your Honor, again, we do not at all are asking or believe the court needs to address that, but just to give you the full flavor of the case, there is a claim having to do with other arguments and claims that haven't been decided yet, having to do with pretextual background to this because when it arose, having to do with the campaign, that type of thing. So again, for purpose of this preliminary injunction, Judge Nichols looked at this issue. We wholeheartedly agree with him. It is not requiring the court to second guess at all.
Well, what if it were undisputable that an app controlled by a foreign government could be used, if downloaded, could be used to by the foreign government as a gateway to be able to hack into email systems and other things of that nature. And for that reason, the president banned the app. You're saying that because of the way that Congress has drawn this statute, that would not be a permissible regulation.
What we're saying, Your Honor, is something different from that. That suggests there's some regulatory void if this is our interpretation of IEPA. I mean, the first thing I would say is in the hypothetical that the president ordered that. Well, this only applies if he uses the IEPA authority to try and do that. The government has plenty of other tools at its disposal. And this is an extraordinary exercise of IEPA authority. The government has never found it necessary to use IEPA for this means. And in fact, there's a declaration by Professor Tyler in support of the preliminary injunction that really puts in context the IEPA authority. But in addition to that, Your Honor, if you look at the text of the statute, what Congress enacted under B3, it specifically references, for example, Chapter 37 of Title 18. That is not, regulation of that is okay. It's not prohibited under the B3 limitation. That has to do with classified information, information about military installations. Congress also referred in there to export controls, also that are not excluded from regulation under B3. So Congress went through very carefully and said what B3 applies to and not, and that's what it did. I'd also say the Walsh case, certainly if there were concerns about data security, I can imagine a regulation that addressed data security in a way that did not have an effect on the transmission of the communications and the informational materials. But if that regulation does what this does and basically stops the functioning of the app, that is not permissible under IEPA. Again, there are other tools, including CFIUS that Congress has to look at transactions and to find mitigations for that. But if it's a security issue and they're looking at the mitigation, that's what you would look at. And again, I guess ultimately, Your Honor, if for some reason all of the tools in the government's toolbox could not address a national security concern, there is Congress, of course, to take action. What we do know is that Congress, not once, but twice, amended the statute to reinforce these limitations on IEPA authority and said, you can't use this economic kind of sanction to shut down this type of personal communication or informational materials.
Correct, but what if, just to follow up on these hypotheticals, if you had an app that was actually 100% owned by hostile foreign government X, very hostile foreign government X. And they come up with this incredibly popular application. And every time it's downloaded, it puts a virus in to the phones and reachable to anybody in your contacts. And it can be released uncontrolled. So as it turns out, when it's first downloaded by everybody, we don't know about the virus. And then it's released. And it starts wreaking havoc across the United States at a time of acute tension with hostile foreign governments. And it's a communication app just like this one. And it's really popular and it's really unique. Are you saying that what the statute says is that the government could not ban people from continuing to download this virus spreading, computer virus spreading application?
What Congress has said is that the IEPA authority can't be used for that. Another tool that the government has is certainly all of Title 18 and all kinds of criminal prohibitions, serious criminal prohibitions.
Stop teenagers from downloading this thing by 400,000 people. I have my memory right, 400,000 people a day, I think, is that what they're claiming?
If there was a regulation that was aimed at the security concerns that met these limitations, that would not be indirect regulation.
But any other regulation, then stop downloading this. It is destroying our communications networks, our computer and mobile phone networks. Don't downloading it. Stop. They have to wait for Congress to come in and pass something?
No.
Yeah, they can prosecute somebody if they can find somebody within their jurisdictional reach, but it seems to me that, there are real consequences to interpreting this language as broadly as you're proposing to national security. And it just strikes me that when Congress said, what they would be getting there is clearly not the communications. It is the friggin' technology that with the technology when it's downloaded, this virus. I don't care what messages you're sending. We cannot have this technology coming into our systems here. It wouldn't have any of the concerns you have. It clearly would not be a regulation of communications. They wouldn't have any of the language you've been pointing to. And that seems to me clearly allowed. That's not a regulation of creating an export.
Your Honor, it's clearly not this case, obviously. I will talk about it. But again, as I said earlier, there might be cases where there's line drawing, where it has such a tangential impact under Walsh. Walsh is clearly—
That's not tangential. It's downloading this communications app, but it's not the communications. We've just got to stop the technology. How textually can you tell me if you can offer? I know you say that isn't this case, and I'm not suggesting that there's any virus with TikTok or anything like that, to be clear. What definition, what term would you use in here to say ruling for you in this case would not require ruling for you in the other case? Is it the indirect regulation?
I would say the ruling in that case would have to do with the fact that there's limitations on B3. It talks about Chapter 37 of Title 18. It talks about various trade regulations. There's the CFIUS authority. There's other kinds of criminal prohibitions. We talk about carriers that have foreign investment license. The FCC has authority. There's a multitude of other tools that the federal government has. IEPA has not ever been used, nor need it be, to do that. There are other tools and there are limitations within the B3 itself.
So your view is there's nothing we can do to interpret B3 that would say government can stop under IEPA my virus hypothetical if we rule for you in this case. But your argument is there's authorities elsewhere.
There certainly are authorities elsewhere, Your Honor. We
don't have an argument that B3 can be interpreted to allow them to ban that hypothetical, that software download if we rule for you in this case.
we think that when you're looking at that type of situation, is such a far cry from this situation where, and I just want to clear her going to the purpose. I mean, Judge Nichols has looked at the purpose, and
I understand. No, I really do, and I'm not.
That could be a different analysis, Your Honor. Is what I'm saying is that the purpose there was for this overwhelming national security thing. That would be very different from here. So that might be another distinction.
What word in here lets me look at have a purpose-driven analysis in B3?
Judge Nichols believed that the idea of regulate and the objective of what is being regulated goes to the purpose. And that's why he so closely looked at the Commerce Department memo and looked at how its aim is to shut down these communications, these videos, these messages. So that would be another construction that when the day came.
Do you agree with that? If in this case, it were crystal clear that they were just trying to stop these downloads. They really were. They had all the affidavits, all the fact finding. That was their clear purpose. Change the record any way you want so that 100% of the evidence of purpose is simply to prevent the business-to-business sales that allow this download. Then that subjective purpose would prevail and it would be okay, even if, as it turns out, it's stopping an awful lot of speech.
We don't think there's a purpose requirement. We argued that to Judge Nichols. But what I'm suggesting to you, Your Honor, in your hypothetical situation, so for this case today, it doesn't matter whether there is, because as Judge Nichols found, it's the purpose and effect to directly regulate this, at a minimum, indirectly regulate the videos, the messages, etc. So it doesn't need to be resolved for this case, nor does the situation, the other hypothetical, need to be resolved for this case. But taking your Honor at the question of what is the government to do, we would say three things. There are a lot of alternatives. IEPA has never been used. Even within IEPA, the B3 itself, Congress is very clear about classified information, military installations. And third, there is Judge Nichols's approach that would say purpose would address your situation also, that the purpose there would not be to regulate the content or the video. So those are three answers I would propose to your hypothetical, none of which are necessary in this case, nor need be reached in this case. And, we agree, Your Honor, that purpose is not in the statute, but we clearly meet it here as the district court found.
How do you draw the line on distinguishing between indirect regulation, which isn't allowed, and some sort of permissible burden, which is?
We would look to the Walsh case, Your Honor. We think that the language there of tangential effect is very useful. It really goes to the thrust of what indirect regulation means. If you are trying to stop the import of something or stop the transmission of messages, and you just say, I'm just going to shut down the way they get paid or the way they use the app, that is indirect regulation. But if you're doing something else and all those messages are still flowing, those posters are still being imported, but there's this other thing that, you can't use US hard currency to travel to Cuba, where you want to get your posters from. Well, that pretty much has a tangential effect. And the court pointed out, you could get your Cuba host even to have you come there.
So could the president here have said, unless and until, TikTok needs to change its license and disable certain features in the software that we think pose a national security problem, and we're giving them, 30 days to do that, and if they don't, then the app is banned from further downloads. Could the president do that under IEPA?
That gets much closer to the type of regulation I talked about that was, we could envision that's focused on data security, that speaks to that, and that would not affect the ability to transmit communications. But I would say, Your Honor, even more fundamentally, this goes back to part of my answer to Judge Millett, too, about these other tools. CFIUS, which is the Committee on Foreign Investment in the United States, has that type of authority to mitigate national security concerns having to do with various transactions. There currently are ongoing discussions under that very authority. The president issued an order under CFIUS about a week after this order, and those negotiations and discussions are still going on, and that's an appropriate place for that. We disagree with the breadth of the government's actions there and have filed a petition for review of that agency action in order to preserve our rights while these discussions continue. But that is exactly what, again, Congress created to address those very concerns. And I can't say enough, Your Honor, how important it is that we look to how Congress has looked at these various issues.
But why isn't it relevant to us? I mean, when we interpret a statute, we don't normally look to see, well, if we interpret it this way, we shouldn't be worried because all of these other statutes, can cover, these other situations. I mean, we need to look at the text of this statute and to see, given the concern that Congress had, which is to give the president the ability to act unilaterally once the proper declarations and procedural requirements are made to protect national security. And if you have a hypothetical case where there's no question there's a serious national security risk that's posed by software that's downloaded on mobile phones, it seems to me that your interpretation that you would ask us to adopt doesn't allow the president to use this authority to act. I mean, even in the hypo that I just posed, that if the president says, look, change these particular things about the application and do it by this date, or I'm going to block the application, you don't seem to be willing to admit that that is permissible because of B3.
Let me be clear, Your Honor. I did not mean to say that was not permissible. I think it's more appropriate under CFIUS because this whole regulatory scheme set up for mitigation and all of that in a process. But here, Your Honor, a regulation, if the Commerce Department had done that, again, we have to look at what the Commerce Department did here. They didn't do that at all. If the Commerce Department were looking at that and had some targeted national security concern, and they have a record to support it. And again, I have to say, in that situation, they would have had to give us notice and comment to respond. We didn't get notice and comment to respond, so we couldn't even explain to them all the security measures that we do have in place. There's a declaration below that explains that. I mean, that's not all relevant to the statute thing, but I'm just giving you the context. If that had played out, it would have played out very, very differently. And that well might be something that did not indirectly regulate communications because there could be measures taken that didn't affect the communications. So I just want to be clear about that. I'm sorry I was unclear before. I was perhaps jumping too quickly to the other method that's allowed there. So that is an approach. But I would also say it's not our interpretation. It is the words of Congress. And this is at A3 of our appendix.
Can I just follow up here on your answer to Judge Wilkins? Are you saying that if they gave you that, they went through whatever process you want, and they gave you that, look, you've got 2 months or 1 month, and then we are banning download of the app? At that point, banning download of the app would not be impermissible?
If it banned the app, Your Honor, it would not come to that because there are all of these data security provisions that can be taken. In fact, TikTok tapes them. That's what the declaration indicates.
But ends up being, after that 1 month period of intense negotiations, the government and the company are not in agreement. And so the ban comes into effect. And it's not because they didn't try, and maybe they did do some adjustments here and there, but the ban comes into effect, and IEPA is the authority for the ban.
Well, CFIUS is the authority. CFIUS cross-references IEPA. So I take it, Judge Wilkins, for example, sometimes you do look at more than one statute because they cross-reference each other. And it explains if IEPA doesn't satisfy, then you can do this under CFIUS. So I think you'd have to look at the interaction of those two. And in fact, the Commerce Department regulation here, Prohibition, does look at the interaction between the two because it even acknowledges that the prohibitions will not apply to activities that need to be taken to address the CFIUS issue. So I do think there's an interaction between those two authorities. But I do also have to—
I mean, it could be banned. They just cited the wrong statute this time?
No, Your Honor, it's a different process. And the CFIUS has the mitigation authority. But what I'm saying under IEPA, if there is a regulation that is addressing data security that does not go to and affect the actual transmission of the messages, you know, whether it's encryption, prohibiting malware, there are lots of things that could come under that. That would be different. That's not what the Commerce Department did here.
I understood. Maybe Judge Wilkins, correct me if I'm wrong. His hypothetical was you have a time period, and if you haven't worked everything out, a ban on download goes into effect on day. And what I'm asking you is, would that be ban when it goes into effect? The process just didn't lead to resolution. Would that be permissible? You're saying that would be permissible under CFIUS authority, but not under IEPA or under IEPA?
That would not be allowed. An ultimate ban that shut down, you know, the informational materials, the transmission of informational materials, photographs, etc., within B3 would be an indirect regulation of those informational materials that would not be allowed. But under the CFIUS authority, there are other authorities that are not limited. CFIUS is not limited by B3. This is a statutory textual.
CFIUS could impose a ban after 30 days. CFIUS could impose the same ban that was imposed here.
I can't speak that broadly, Your Honor. That's why I'm hesitating. There are ongoing negotiations, and ban is a very generic word. We take issue with the scope.
It cannot be downloaded by new users and cannot be updated by existing users. That's what I mean by ban.
Right. And what I'm saying in the CFIUS context, it has to do with covered transactions and various uses of its authority that are in ongoing discussions now. Hypothetically, I'm sure there are situations where that would be possible. I just can't speak to this particular situation because I'm not privy to the CFIUS negotiations. I'm just the litigator here. But I want to bring it back to the text of B3.
I'm asking the question just because if the argument is, if we have a real crisis like Judge Wilkins hypothesized or my virus one, it's a real crisis and it really is focused on technology. That's the real problem. And I thought your argument was, here's the process for dealing with that. But if it doesn't actually allow them to stop the hemorrhaging, to stop the downloading, then it seems like it's not. Is there some other authority that would let them go stop the downloading of this virus spewing technology? And we'll sort it out later, but let's the government go fast and stop the downloading.
Why don't we—
The government has—
Go ahead, Mrs.
The government, thank you, Your Honor. The government has many authorities, Your Honor. I can't sit here and catalog all of them, but there certainly are export controls, import controls that are allowed. There are anything that would be tangential, but I would also say, Your Honor, again, if that day comes and that issue is presented, it would be such a different situation than this. And I just want to say again, it goes to this question, for example, of purpose that Judge Nichols focused on. Here, it's clear that the purpose and effect here is to stop the transmissions of these communications. But he suggests, and that I'm suggesting to you could fit your hypothetical. If there was some purpose under his approach that had nothing to do with the actual communications, that may be something. That just is not something that the court needs to grapple with today. And I think there are a lot of different analyses. The interaction with other statutes, the interaction with other national security authorities of the government, and the idea of a situation that's different from this, where the purpose is wholly different than what the purpose was here. So I would say all of those, I think, should get comfort and address the situation. There are tools for courts and the executive and the government to look to. And of course, there also is the authority of Congress. But I take your point that you're looking for something emergency that could be done directly. And I would suggest that other tools, the purpose, all of those things are a way that could arise in another situation that isn't present in this case. And that is what we're looking at here today, Your Honor. It's a question of statutory interpretation what Congress said and expressly said, the authority granted to the president by this section does not include the authority to regulate or prohibit directly or indirectly, and then it has the personal communications and the informational materials. And the informational materials is quite broad, commercial or not, regardless of format or medium, twice amended in the Berman Amendment, and then again in 1994 in the Free Trade and Ideas, to ensure the robust international exchange of ideas. And that is what Congress wrote. There are other authorities, there are interactions between these statutes, and indeed there's Judge Nichols's approach, particularly in his more recent opinion last week. He issued another opinion on the case and really went through and analyzed his approach, I think, to purpose, which might address your issue. Again, you know, we don't see that in the statute, but it just doesn't matter here because it's so clear, and the record is so clear from the Commerce Department's memo about the purpose and effect of the prohibition at issue here.
All right, why don't we hear from counsel for appellant?
Thank you, Your Honor.
Thank you, Judge Rogers. I want to make a couple points in just to address what my opposing counsel was discussing. So first of all, the statutory language here protects the rights of Americans to certain activity like importing informational materials. It doesn't protect the rights of businesses or foreign governments. And that's important because Walsh emphasized the need for line drawing. There was a discussion about line drawing, and it's indisputable that Walsh recognized that there's a need to balance the two congressional concerns, as the court said there on page 1233, recognizing Congress's intent to give the president wide powers under AIPA to address serious national security threats.
But let me ask you, just so we're clear, you have not argued that there are not other statutes, other procedures, other ways in which the president would have authority to ban downloading an app.
Actually, Judge Rogers, that we haven't addressed that question, nor have plaintiffs in the briefing in this case. And I think it's important.
No, but it's obviously something of concern to us.
Yes, and I think that concern is serious because I don't think anyone has identified a similar emergency authority to address the kind of imminent threats to national security that Judge Millett and Judge Wilkins in their hypothetical examples posed. AIPA is designed specifically to address those kinds of threats. And the fact that a particular business or a particular foreign government seeks to hide a national security threat in a business or an activity that allows Americans to engage in personal communications or exchange of informational materials does not insulate that business from regulation of the threat it poses to national security under AIPA. The other point I want to emphasize is that the plaintiffs acknowledge there's a national security concern here, but they nevertheless double down on this interpretation that AIPA doesn't reach this kind of national security threat if there's any implication, any effect on communication or informational exchange. If this were a rideshare app or a video game app, collecting the same sensitive personal information, there's no doubt AIPA could regulate it. Can't be insulated just by pointing to the fact that Americans might wish to use it for these protected activities. That's not what Congress intended. And finally, I want to emphasize that Walsh's reference to the tangential nature of the travel at issue there was not the court's articulation of the standard or the meaning of indirectly regulate or prohibit. It was instead an example of the court's Chevron deference to the Treasury Department's own rationale for why it retained the travel regulation.
Nope, you're mid-sentence. Go ahead. Sorry.
No, Your Honor, please. Sorry.
I wanted you to finish your point. Go ahead.
I did. Thank you.
I'm sorry. I know we only have the first prohibition before us, but on this theory about use of the web browser, with the fifth prohibition, when it says no utilization of TikTok's mobile applications, constituent code, functions, or services, the functioning of software or services within the United States. Would that ban use of TikTok through the web browser?
Your Honor, we don't know the answer to that yet, but I think that it might not. And the reason is that the language of the fifth prohibition, again, like all of the prohibitions and the executive order, reference the TikTok mobile application. That is the particular threat identified.
I'm trying to figure out what constituent code functions or services are and whether those are actually in any way distinct from using it through the web browser, particularly if you use the web browser on your mobile phone.
Yes, Your Honor, but it wouldn't be using the mobile app. So again, these are questions that probably remain to be explored in terms of
web browser alternative.
Sorry, Your Honor?
We're not at all clear about this web browser alternative, really.
Correct. And I'll just point out that the only reason I mentioned it is because this prohibition at issue here is limited solely to the mobile app, and it's limited solely to its availability on app stores. That is a targeted regulation designed to address the specific threat identified. It is not the kind of, in reality, ban of importation or exportation of informational materials or personal communications. That is the meaningful difference that I think is relevant, not whether web browsers are different in some other way, Your Honor. And that, like the other questions that plaintiff has raised in their complaint, remain to be resolved as the case proceeds on the merits in district court. This question before the court now is whether the preliminary injunction can be upheld solely on the basis that the district court articulated that it is an indirect regulation of Americans' protected activity. That's not what the statutory language means, as the court recognized in Walsh. And we think that disposes of this appeal, Your Honor.
Can I ask you about timing as well? This is an expedited appeal, but my recollection is correct. The government never sought a stay of the preliminary injunction and now has published in the Federal Register a statement that in light of sort of this injunction, I think, can't remember if that was after or before the December 7th injunction, that they're not enforcing it. And my understanding is that the November 12th deadline went by and those prohibitions are not being, there's no one, it wasn't until December 7th. The November 12th deadline came and went. And at least until December 7th, there was no injunction, and yet the government was just not enforcing.
There was, Judge Millett, oh, I'm sorry, Your Honor.
No, that was my understanding. Tell me how I'm wrong. Am I wrong?
So there was an injunction, Your Honor. It was entered by the district court in Pennsylvania in the Marland case, which was brought by 3 users of TikTok, and it enjoined all 5 prohibitions. And you're correct, Judge Millett, that the government did not seek a stay in this case of the injunction of the first prohibition, and instead we sought expedited resolution, and we'd urge this court to rule expeditiously as well in order to address and protect.
Case? Have you sought a stay in the Pennsylvania case?
We have not, Your Honor. We also sought, and the court granted, expedited briefing and argument of the appeal. The briefing is proceeding very rapidly. We filed our opening brief, and the court has set argument for February, I believe, 14th and 15th.
It's just a little bit unusual to me in a case, national security, one, not to have any declarations here, even if under seal, by national security officials telling us the urgency of these actions, and then in particular not to have the government seeking a stay. So I'm just trying to get a measure here from the government. So you've got a February argument date in the Third Circuit, is that what you said?
Yes, Your Honor. That's correct. Okay,
so you're not even expecting decisions until late
Your
February or on February, maybe at the fastest.
Well, we've asked this court and we've asked the Third Circuit as well to rule expeditiously. This case.
What we do if there's another injunction in effect. And that Third Circuit decision, again, if you're giving an argument in, sorry, was that February 14th? Am I remembering that for some reason?
I don't remember the day in February, Your Honor. It is in February is all I can recall.
Yes.
So if I may address your question though, Judge Millett, this case is the furthest along of the appeals. And we're asking you to rule expeditiously in light of the national security concerns identified. If this court rules in our favor, we could seek additional relief in other courts, and that could be a basis for doing so. We thought it was better not to impose a burden both on the court and on the parties in this case to duplicatively brief both a stay and expedited briefing. And we thought that it was essential to allow the court to consider the merits questions posed, the likelihood of success on the merits, that is, posed by this case. And so we sought expedited briefing instead of a stay, and didn't seek a stay, I should say. There's nothing untoward about that. Nothing undermines the national security rationale here. And indeed, as I emphasized, and in the plaintiff's argument, opposing counsel acknowledged, the national security threat is legitimate, and there's no basis to second guess the president's determination on that question.
Is there any timetable for the committee to act?
You're referring to the committee, the CFIUS proceeding, Your Honor, and I am not familiar with the details of that. My understanding is that that's a separate track, but I'll also point out that the plaintiffs have filed a separate petition for review in this court, which will proceed on its own track concerning that statutory process.
All right.
We think it's not relevant, however, to the interpretation of the exception in 17.
Advisement. All right. Thank you.
Thank you, Your Honor.
Just give me a second to switch materials, please.
Case number 20-5035, Pavement Coatings Technology Council, appellant versus United States Geological Survey. Mr. Ebner for the appellant, Mr. Koppel for the appellate.
All right. So who is number 11? Mr. Byron A. Ann?
Excuse me? I'm sorry, Judge?
I see two attorneys and another person, and I'm asking you who that other person is.
I am not seeing another person, Judge. I am seeing the three judges, the timer, and two attorneys.
Well, I have another person on my screen.
I am not seeing anyone, Judge.
There's someone on the screen and Mr. Byron, appellants.
You know, now he's gone.
Okay.
Oh, all right.
Got rid of it. All right, thank you. All right, counsel for appellant. Good afternoon.
May it please the court. I'm Lawrence Ebner, and I represent the Pavement Coatings Technology Council. USGS is asking you to expand FOIA Exemption 5 in a way that would insulate all federal government scientists from external criticism of their published research. According to USGS, a government scientist can hide behind the deliberative process privilege simply by labeling essential study-related data as exploratory analysis. If USGS is correct that the deliberative process privilege applies to scientists' thinking, virtually all federal government research is going to be covered by an exemption that is supposed to be construed narrowly. We believe that concealing scientific data so that a study cannot be discredited is not the purpose of the deliberative process privilege. For example,
That just be clear, you have the data itself, correct?
the only data that we have are the raw laboratory data.
That's exactly what I'm referring to. You have the raw data.
Yeah.
What you do not have is two people who have analyzed this data.
What we do not have, and what we
And the 4 out of 200 options they have here.
That's correct. We do have, and Government Counsel will tell you, USGS has produced tens of thousands of pages of raw laboratory data. Those data are primarily lake sediment, chemical analyses, and measurements. They are useless to us without the computer modeling inputs and outputs that we seek. In this case, many state and local governments have relied on the Urban Lake Study publication to ban the use of refined tar sealant. The published study does disclose the computer modeling input and output data only for what the study authors describe as their 4 best modeling scenarios. Those are computer modeling runs.
You have all of the raw data, and you have these 4 models. Why on earth couldn't your own scientists, with all the raw, they know the question, they have all the raw data, they know what models were used, they could run it, and then they could tweak and redesign the models to test, just like these scientists did. That's what scientists do. Why can't you do your own model runs with the same data?
Judge Millett, I think that one of the study authors, Dr. Van Meter, answers your question in his declaration, where he explains that there were so many possible combinations of inputs for a given model that the possible outcomes are virtually limitless. And in fact,
that won't change if they give you the other model runs. So I'm trying to understand why, if your concern seems to be the FOIA interest here is knowing what other models were tried, what changes, what tweaks or adjustments were made to these 4 models that they didn't use, they didn't treat as their 4 best models. And any scientist can come up with their own tweaking to models, try their own changes. They can take all those variables and make all those changes. So you don't need, you may want it, but you don't have a need for that information to understand what the government did. You can test the government's theory because you have the data.
With respect, Your Honor, all we can do with the data that has been provided is to try to replicate what the study authors describe as their 4 best modeling scenarios. Modeling runs.
Your scientists aren't capable of designing their own model runs?
There are so many possible combinations that what we want to do, Your Honor, is take a look at the other 200 modeling runs that the study authors chose not to use in their published study and not to disclose. They're saying in their published study, trust us. Those other 200 modeling runs are going to confirm the four modeling runs that are discussed in the published study. In order for us to replicate the other 200 modeling runs, we need not just the raw data, but we need to have the input and output data so that we can run those other 200 models and see, for example, whether they report
You have all the data. You have the data that they put in and you have the data that came out.
We do not, Your Honor.
I thought you had all the raw data. Are you saying there's raw data that wasn't disclosed that they input into their model runs?
There's a distinction, Your Honor, between the raw data and the computer modeling input and output data that we seek. USGS on page 12 of its brief explains that modeling data are critical, that's their word, critical to scientists' ability to analyze the raw data.
So you have the raw data and you have their 4 runs, right?
Yeah. What we want to do is duplicate.
You want to do the 186, whatever.
Approximately 200 modeling runs that they ran, but won't tell us what those modeling runs are. And in order for us to test the study's conclusions based on their 4 best modeling scenarios, we need to know what all the parameters were, not just the raw data, but the parameters and the combinations of parameters, which Dr. Van Meter says are virtually limitless, in order to see how those other 2 modeling runs come out and see whether they really do support what's in the published study or whether they undermine it. And I'd like to point out—
in other words, you want to be able to see whether in their deliberations they deliberated and reached the best conclusion or not, right?
I wouldn't call it deliberations, but we would like to know whether uh, their study, for example, suffers from confirmation bias.
Yeah, I
Where
mean, my point, sir, is that to say that you aren't really seeking to understand the deliberative process of these scientists seems to be like saying that there's no gambling going on in Casablanca. I mean, the whole purpose of this request is that you want to undermine their deliberative process because you think that it has been infected by bias or incompetence or whatever, right?
Well, yes, Judge Wilkins, but the scientific deliberative process, which is really the scientific method, is not the same as the deliberative process that's contemplated by FOIA Exemption 5.
Okay, so then let's get down to brass tacks. You do want to invade their deliberative process, but you believe that scientific deliberative process is not covered because that's not policy deliberative process, right?
It's not only not policy, but it falls within the distinction that the Supreme Court and the DC Circuit has drawn for many years between purely factual information and drafts and so forth that go into the formation of policies and recommendations. We are not seeking, for example, any notes or memos or emails that these scientists may have generated that analyze or evaluate or discuss the modeling runs. We're not asking for drafts of the proposed study. We're not asking for internal USGS comments on the proposed study. What we are asking for is pure scientific data, which are contained on spreadsheets, charts, and graphs. And I might point out that USGS's own internal manual defines data as non-interpretive. And I'd like to refer the court to the American Radio Relay case, because in that case, the court held that a federal agency cannot invoke FOIA Exemption 5 in order to hide parts of a study that are inextricably bound to the study as a whole, that may contain contrary evidence or may help to eliminate the strengths and weaknesses of the study.
Disclose the whole study. So you have all the data, you have the final study with the 4 runs, and you want the other 196, which I gather from your statement, you're saying the agency still has.
They still have. They refuse to produce them. There's nothing inherently deliberative about them. If these kinds of data, input and output data, were inherently deliberative, they wouldn't have disclosed the inputs and outputs for what they call their 4 best modeling runs. So, and to use the word that USGS uses in its brief, what we seek, the input and output data for the other 200 modeling runs, are critical to the ability to analyze the raw data that they produced. They basically dumped tens of thousands of pages of raw data on us and said, we should go, figure out by an infinite number of permutations what their other 200 modeling runs were, because they won't tell us. And we don't think that's what's contemplated by FOIA Exemption 5.
To be clear about something, you already have the data. It's just not labeled input and output? Or are you saying there's raw data you don't yet have?
Well, I'm using the term raw data like the study authors do, which is the lake sediment measurement, which is one of the inputs into the computer model.
You have all the data. It just doesn't come with a label input and output.
No, Your Honor, we do not have the input and output data. Another term for that is the modeling runs.
Okay, that's different then. Let's just call it model runs versus data. You've got the raw data. Let's not call model runs data, because I think that's a question in its own right. So let's just call it model runs instead of saying you don't have certain data.
Model runs represent the inputs and the outputs. There were more than 200 of them. and USGS has refused to produce them, and we cannot test the Urban Lake study's conclusions without those other 200 model runs. We cannot do it just with tens of thousands of pages of raw laboratory data. We cannot do anything.
The articles were peer reviewed before publication in the journal. Does the peer review process require disclosure of all 200 model runs?
We don't know whether those 200 model runs were disclosed, but in our brief, we cite, for example, Nature Publications policy, which does require scientists to make all the data available. And I'd like to point out—
Sorry, this is where we keep, the language here is troubling to me, because they've made all the data public. And then the article went through a scientific peer review process. In fact, it's been they have a number of publications, all of which have gone, my assumption is, tell me if I'm wrong, scientific peer review process. And there's no argument by you that they lost this privilege because they disclosed all these model runs as part of the scientific review process.
Your Honor, there's nothing in the record indicating that the 200 model runs, which they refused to disclose to us, were disclosed to the peer reviewers in the two publications that ultimately published what they call their 4 best modeling scenario.
You have a FOIA request that says all of your model runs that have been disclosed to members of the public already.
Well, we originally filed a very broad FOIA request, which would have encompassed that. And I have no reason to believe that the withheld model runs, which consist of input and output data that they have not provided, were provided to the peer reviewers.
But counsel, whoops, sorry, Judge Wilkins.
I just wanted to ask one question, Judge Rogers. But even if they had been provided to peer reviewers for the purpose of peer review, that wouldn't mean that they were public in the sense of they would be outside the protection of the deliberative process privilege in FOIA, right? Because the peer reviewers would have been reviewing them kind of on the same terms that someone reviews a draft article for publication, with the requisite confidentiality, protections and that flow with that, right?
The peer reviewers' substantive and editorial comments on the proposed publications would be covered by the privilege. We are not seeking that. We are just seeking the data. And my understanding is that when a scientist in academia or the private sector, for example, publishes a study, they must make all study-related data available, not just to peer reviewers, but to anyone upon request.
No, but you've been making certain assumptions throughout your brief and here. Let's hear from counsel for appellee, and then we'll give you a couple of minutes.
Thank you.
Good morning, Your Honors.
Morning.
May it please the court. I'm Josh Kopp on behalf of the government. The preliminary model runs are deliberative because they reflect agency scientists' evolving thinking about how to interpret and make sense of the raw data. The council, the Pavement Coatings Technology Council, argues that the preliminary model runs are facts and that disclosure would not provide any insight into the deliberative process. That is wrong. As Your Honors have been discussing, the Geological Survey has already disclosed all of the facts, the raw data. Specifically, PCTC has received the chemical analyses of the lake sediment samples and the PAH fingerprints of the potential sources of contamination. Their own scientists could use that raw data to create any model runs that they wish. What the Geological Survey has withheld are selective compilations and analyses of that raw data that reflect the process by which agency scientists interpreted and analyzed the data.
Were those model runs that they want disclosed to peer reviewers? Is that part of the scientific review process?
Some of them were. Some of these preliminary model runs were encompassed in preliminary drafts of the study, which were sent to reviewers within the Geological Survey and at the journal where the Geological Survey sought to publish the study. Those reviewers gave feedback. The scientists went and refined their model. So some of them were disclosed to the reviewers.
Were disclosed to, I don't care about inside the US Geological. Yeah. Talking about outside the Geological Survey journal. These journals must select the people that they want to do these peer reviews. And some of those folks did get some of these model runs that they aren't getting?
I believe that they did get some of them. Those peer reviewers are within the umbrella for the purpose of the deliberative process privilege. This court held...
It's a very open question after claimant. And
Pardon?
I think that's a very open question under claimant.
I believe that in Formaldehyde Institute versus HHS, this court held that a letter from those peer reviewers...
It was long before the Supreme Court decision in claimant.
That's true. Yes. The district court considered the consultant corollary. PCTC made an argument on that basis in the district court, and they have chosen not to appeal that. So they have not argued that any information was, that any privilege was waived by disclosure to the peer reviewers. So
can I ask you what the relevant agency decision at issue here to which this model run selection process applies? And you've described that as the decision to publish, and not just the up or down decision to publish, but what to publish.
That's correct.
Can you tell me who the agency decision maker was in making that comprehensive publication decision? Was it just these two scientists? Is there someone else within USGS that had to authorize them to publish in their official capacity with their official position noted in a private journal? Who's the decision maker here?
Yes, I believe there are multiple levels of review, including these scientist supervisors. There is an approving official that takes a look at all publications, or multiple approving officials that take a look at all publications that the Geological Survey puts out. So,
and were all these model runs disclosed to them when they made these decisions about their model runs?
I don't believe that all of them were disclosed to those approving officials. The approving officials may have seen some in the preliminary drafts. They certainly knew that these preliminary model runs existed, and they were relying on the feedback that the scientists' peers at the Geological Survey had given to the authors. The approving officials were relying on that feedback to ensure the publication was up to snuff.
To be a deliberative process, it's not just that somebody deliberates inside an agency. The point of the deliberation has to be to inform the ultimate decision maker's decision. So what I'm trying to find is where there's anything in this record that explains how, when these two scientists were running their models in their laboratory or office or wherever they did it, and making these decisions, they were doing that to inform the ultimate decision maker's determination about whether to publish or not, as opposed to they were making it for their own scientific judgments.
Right. Well, they were using these deliberations to ensure that the draft that they present to the approving official would be, the best possible, and that the models that they are seeking to publish are sufficiently reliable, and they are ensuring that through this deliberative process with their peers at USGS, they are ensuring the quality of their research, and the approving official relies on that process in determining whether to approve.
It relies upon them transmitting this information about how they chose the models that they did and the ones that they didn't. And what I'm afraid of here is that this deliberative process might have been these scientists' deliberative process to inform themselves about running of the experiment. But I haven't seen a connection to how, when they reject model runs 3, 4, 5, 6, 7, 8, and 9, they did that to inform that person way down the line years later decision whether to publish or not. And you have to make that connection. Their deliberative decisions have to have been to inform that person months or years later about whether to publish or not.
I don't believe that there is any case that has held that the ultimate decision maker has to have seen the material for it to be covered by the deliberative process privilege.
The deliberative process is to allow the agency to inform the agency decision maker's decision. That's what the deliberative process is. I mean, I worked in government and we would sit around and shoot the breeze debating issues all the time. They weren't to inform any ultimate decision made by the agency. They were deliberative between us, but they weren't informing an agency decision maker's final agency action. And I'm having a lot of trouble getting from, and this may just be my ignorance of scientific process, getting from their deliberations about their scientific study as to those decisions were being made to inform the decision maker way down the road who decided whether to publish.
Well, their deliberations were certainly made in order to ensure that what they presented to the ultimate decision maker would be reliable and would gain his or her approval. If the scientists are considering a number of potential models,
they don't share with that ultimate decision maker 196 no's. Then how did those decisions inform the ultimate decision maker?
Well, they can assure the ultimate decision maker that the scientists have done their due diligence and have looked at a number of options to ensure that they are presenting the most reliable draft for publication.
Deliberative decision to tweak the model here, to not take that approach, to adjust the data here, to include this input and to exclude that input. That never gets passed down the line to the ultimate decision maker.
There were certainly some preliminary model runs that could be discarded out of hand, or some of these preliminary model runs were not intended as actual reliable models, but were intended to test or break the model. So for instance, scientists would use a pristine mountain lake and give the model only urban sources of PAH. And the goal was to see if the model would work in returning essentially the result that there is no result. And so, some of those models were certainly not presented, didn't need to be presented to the approving official, but they were absolutely essential to the scientist's process of reaching the most reliable model results that they could then put in this draft publication, present to the approving official.
You guys picked what the relevant agency decision here was, and you didn't pick the scientific determination by the USGS as to causal relationship between these sealants and these increased levels of this toxic chemical in the water. You have picked the decision to publish. And that's what I'm questioning is I don't see in the affidavits or record here anything that says when these decision makers were doing, these scientists were doing their study, that the model runs you're not disclosing were part of, were deliberations that were undertaken to inform the ultimate decision makers' final agency action of issue.
Yeah, our position is that the agency decision at issue is whether and in what form to publish, and that in what form certainly includes what results to publish. So, which model runs, what the ultimate conclusions are of what are the main contributors of PHS.
All of these 196 model runs with the ultimate decision maker. Did the ultimate decision maker sort of see the whole package of everything they've done?
I don't believe that he saw all of the preliminary model runs. I do believe that he saw the input that the authors received from their peers, some of whom had seen these preliminary model runs. I believe that the approving official took a look at the process that the agency scientists had been through, including their formulation of some of these model runs.
But we don't have any of that in the record, right?
That is correct. I don't believe that what the approving officials look at is in the record. But again, I don't think it is necessary because these agency officials are acting on behalf of the agency, and the deliberative process privilege covers the process of the agency, including the lower level scientists.
But you have the burden of establishing the privilege, right? The appellant doesn't have that burden. Plaintiffs don't have that burden.
That's correct, but I don't think it's relevant what the approving officials saw or didn't see. What's relevant is that the agency officials, the agency scientists, as part of their decision-making process, were using these preliminary model runs to test out their hypotheses and to test out different approaches for analyzing the raw data. And
what's in the record is that, and what you've said in your brief is that this is basically kind of how you calibrate a model, right? This is standard this is something that's done in any instance where you're trying to develop a model to replicate or to, try to replicate and answer a question, right?
Running preliminary model runs, I believe, is quite standard. Which
So
models?
If that's the case, then where is there evidence in the record that if we disclose these model runs, or we order their disclosure, that it will discourage them from being done in the future, or that it will somehow harm the quality of future agency decision making?
So which models the scientists run is an extremely subjective, it is an exercise of subjective quantitative and qualitative judgment. And we can certainly, I believe that if the agency scientists knew that their preliminary model runs were going to be disclosed, they would certainly be less candid, for fear of being ridiculed.
That's not in any affidavit. That's not in any of the declarations.
I believe that Dr. Van Meter and Dr. Van Mahler, I believe that they both say that they would be discouraged from running some of these preliminary models if they knew that they would.
I did not see that. I'd like for you to find that language because I looked for it and I didn't see it.
Yes, I can take a quick look, Judge.
I think that the best that they say, if you look at JA 27, Dr. Van Meters, is that it will give outsiders an opportunity to confuse the public and discredit our work. And so they say that they don't, they think that's something bad that will happen, but they never says that in the future, then I'll do preliminary model runs differently, or I'll be inclined not to do them. And there's similar language in the declaration from Dr. Mahler, but I don't see anything that says that disclosure of this is going to kind of change the way that we do our business.
I'm not sure if they explicitly say that it would change the way they do their business. They do say, as you mentioned, that it would confuse the public. And I believe, first of all, that is its own interest protected by the deliberative process privilege, public confusion. But I think that we can certainly imagine, if we took another context, for example, climate change. If agency officials knew that their climate change research, all their preliminary models would be disclosed to the public, agency officials might pressure lower level scientists to only run certain models that are consistent with what those agency officials want to ultimately publish. Or the scientists themselves may feel inhibited from running certain models if they are afraid that those models will show something other than what they think their ultimate conclusion will be.
Those models are not done for publishing articles in a journal. Those are done for deciding what the final agency position or agency action will be in a regulation or a policy of some sort. The difference here is, it seems to me, you've picked an unusual agency action, and that is to publish an article in official capacity. And what I'm having trouble with is that you seem to be conflating the decision to come to a reliable scientific result through this trial runs, the scientist's own decision and concern about doing that, with the decision of someone else who you said there are many layers of review. So I don't know how many layers this is, but apparently there's somebody at the end who signs off and says, yes, we will publish this in the name of the U.S. Geological Survey, or at least they can use their official titles. Does that mean, I guess I should clarify one thing, does that mean it's a United States Geological Survey position when scientists publish in a journal in their official capacity?
Yes, I believe that's correct.
We believe that's correct, but we don't even know that. So I'm so, right? So I'm not even sure if that's what's going on here. But I will assume that for now, because they get to use their official titles. But that just, there seems to be an awful lot that's happened in between. And I'm just not convinced every time they're standing there a year or so before and they run a model run and they go, that's crazy. But it was part of the decision whether to tell someone way down the line, this person, whether she should authorize them to publish in their official capacity. And that's the connection I think we need for deliberative process.
I think this is no different than those draft agency histories that were at issue in Dudman and Russell. In those cases, the court wasn't concerned whether the ultimate decision maker had viewed the preliminary drafts. If there was a preliminary draft that got changed somewhere along the process, somewhere on its way up to the official in the Air Force that was going to ultimately approve whether these draft histories were made public, that was enough. Because it exposes the deliberative process of the primary author, or really of anyone inside of the agency that's helping to formulate the history at issue. And so, those cases also, of course, involve publications rather than policies.
On there to write up the history. Maybe I just don't know how these folks work. When these scientists started this process, was their goal to write an article, or was their goal to make a scientific determination about the relationship between this pavement coating and toxins in water?
My guess is that I think that it was both. They expected to make a determination of the relationship and to publish those findings for the benefit of the scientific community. Because the Geological Survey doesn't make policy or.
I don't have that on the record either.
Well,
we don't have them saying what the point. Their deliberations, as they describe them, seem to be to get this science right, to figure out this question. That's what they're deliberating about. And then,
that's right, but also to publish it for the benefit of the scientific community and the benefit of the policymakers.
Do the declarants here, the two scientists that did this study, do they state in their declarations, because I didn't see this either, that we were making this deliberative decisions to inform the ultimate decision maker on whether or not to publish this in the name of the USGS?
I'm sorry, can you repeat the question?
In their declarations, they say when we were making our decisions about these 196 model runs that we rejected, or the 4 that we thought were best and why we thought they were best.
They were making that
because we wanted to be able to inform the ultimate decision maker about whether to publish?
They don't say exactly that. They say that these preliminary model runs were an essential part of them forming their ultimate conclusion, which was then approved by the approving official and published. Pardon?
The scientist's ultimate conclusion was a scientific relationship.
That's right. Yes, this is no different, I believe, than a professor workshopping a paper at a university. He receives feedback from his or her peers and then goes back and refines the paper. And that's exactly what is going on here. The scientists...
When they went to these outside journals, this wasn't a government journal that was published. It was an outside journal. Right. And then did the government pick the peer reviewers or did the outside journal?
The outside journal.
Outside journal. And did the outside journal pick those peer reviewers for the purpose of telling the government what the best science is, whether these meet the scientific standard, or for telling the journal whether these meet proper scientific standards to be published?
I believe the intent of I can't speak to the intent of the journal, but I believe that it is to inform the journal whether the paper is worthy of publication, but also to help the study authors get the publication into shape, because it's not the reviewers don't give a yes or no, up or down. They give feedback to the authors who then go and modify the paper, edit, run new models.
Modify it because it's not getting published unless they clean something up. But I assume the point of it is to have comments so that the journal knows whether this is something that meets the journal standards for publication.
I think that is one of the purposes, but again, I do believe that part of the journal doesn't select only for its own benefit of giving a yes or no, but also to contribute to the scientific discussion and to aid the authors in improving their research. Unless there are further questions.
You're describing this process, just so let me be clear, is not two separate parts, but rather it's just one continuous effort until a decision is ultimately made to publish.
I'm sorry, I'm not sure which two parts Your Honor is referring to.
Well, I'm just trying to understand. You have these two scientists doing all of this work, and then they decide that the best evidence they have, their view among the models, are the four that they disclose. And then they discuss what they found. So now, here the appellant is seeking not simply the raw data, but it wants the worked up, it wants to understand the background to the workup of the document that was ultimately published. And as I understand it, anything that went into that the parties, the scientists, the head of the survey didn't agree to publish is simply unavailable. You have the raw data, you have the published study with the four, and in that sense, there's a deliberation going on as far as the scientists are concerned.
That's right. What PCTC seeks are the approaches or the interpretations of data that the scientists ultimately decided were not those that were the most reliable and worthy of publication. So using the raw data, PCTC scientists could run these exact same models. What they wouldn't know is whether that model is one that the USGS scientists considered before settling on their four final models that were worthy of publication. So what they seek is insight into the deliberative process. I mean, exactly. They have the raw data, they have the results. What they don't know is what approach the scientists use to interpret that data on the path from raw data to ultimate publication. Unless there are further questions, we ask that your honors affirm the judgment of the district court.
All right, counsel for appellant.
Yes, thank you. Well, again, we're not seeking interpretations. We are only seeking the 200 modeling runs. And we heard government counsel just explain that with the tens of thousands of pages of raw laboratory data that they have provided, we can try to somehow do our own modeling runs with all these limitless possible combinations of input variables and try to guess what their 200 modeling runs were. I'd like to refer the court to the declaration of USGS FOIA officer Brian May. He says in his declaration, first of all, that the withheld model runs were not used in the final decision.
What page of the JA are you on, please?
That would be in the appendix on page 49. He says that the withheld modeling data were not used in the final publication, were not used in the, quote, final decision. He also says on page 53 of the appendix that it was the USGS approving officials, those are the people who ultimately approved publication. It is the USGS approving officials, quote, internal discussions and, quote, candid feedback to the study authors that, quote, comprised the USGS deliberative process. We're not asking for any documents reflecting those internal discussions. We're not asking for any documents reflecting the candid feedback that the approving officials gave to the study authors. We're not asking for any deliberative documents. We just want the modeling run, which we've described as the input and output data. And the other point I'd like to make.
My question then is, I know you characterize it that way, but is that an accurate way to characterize it?
It is.
The scientist takes the raw data and does something with it, right?
Yes, I think the answer to your question, Judge Rogers, is set forth in the declaration of Dr. Van Meter, who is one of the two study authors. He explains in detail not only how they selected a particular computer model, but also how they formulated a modeling run. He explains that the modeling run includes the raw laboratory data, the sediment readings, and the PAH profiles. There's more than a dozen different types of PAHs. Then he talks about the modeling parameters, and he explains. It's kind of like turning the knobs on a stereo hi-fi. There's all different ways to do it, and he says there are so many possible combinations of inputs and modeling parameters. The possible outputs for a given model are virtually limitless. And the other point I'd like to make in rebuttal.
Well, let's finish up on that. He's describing the intellectual element that goes in between the raw data and I'll call a draft. And then it goes through some refining processes, but it's still the scientist's input.
That's correct, Judge Rogers. And what you have just described is the scientific method, a method that Mr. Koppel said was standard running these computer modeling runs. And I think the question for the court is whether the court would like to take the unprecedented step of stretching Exemption 5 to encompass the entire scientific method. And if the court were to do that, in this case, it would set a precedent for federal government scientists in all agencies that employ federal government scientists. And any federal government scientist, just by tagging modeling data as exploratory analysis and saying, well, it was my scientific deliberations, would be able to hide the ball, which is exactly—
You're saying that we would be taking an unprecedented step, but I don't recall seeing you cite anything that says precedent-wise that says that the scientific method is outside of the deliberative process privilege.
Well, I think one case we've cited, for example, is the American Radio Relay League case.
I'm familiar with that case, as you know, and that's a different case. There was a study, and the agency had to release all of it. Now, we're between the raw data and the ultimate study. American Radio is at the study. Now, you're asking for something that happened in between. And the question is whether or not that comes within Exemption 5 or not.
No, our request refers to the Urban Lakes study, just like there was a study involved in the American Radio Relay case. And what, at my understanding from reading that case, is what the FCC was trying to do in that case was to hide, and that's the word used in the decision, hide parts of the study.
I'm asking you, is there something between the raw data and the published report?
Yes.
What is it?
The modeling runs.
But that's not a study, is what I'm trying to get at.
It's an intrinsic part of the study. The word study,
okay.
The word study can be the scientific method, or it could be the publication of the study. And what we have here, is a scientific process that the study authors conducted, running more than 200 modeling runs. That culminated in a proposed publication, which, according to their words, only disclosed the modeling runs for what they considered the 4 best modeling scenarios that say basically that refined tar sealant is the primary source of PAHs in urban lakes, and they refused to disclose the other models, as Your Honor has pointed out. And what counsel for the government is doing—
Go ahead, excuse me.
What counsel for the government is doing, respectively, is conflating a scientist's deliberative process. Well, he began his argument by referring to scientists' thinking. That's also the term used in their brief, conflating that with the agency's deliberative process on whether to publish a study that is presented to them by agency scientists. And again, FOIA Officer May says that the modeling runs that were withheld were not used in that final agency decision. He says what was the USGS deliberative process were the internal discussions among the USGS approving officials and the candid feedback they gave to the study authors. We don't know what that feedback was. We're not asking for that in this appeal. We just want the modeling runs, respectively. And one last point, if I may, very quickly. This is a very influential study. As we point out in our brief, it along with the House study, which we haven't had time to discuss here, but is discussed in our brief, have led many state and local governments to ban this product. And although USGS doesn't set policy, even a casual look at their refined tar sealant webpage indicates that they rely on these studies to essentially recommend that state and local governments ban the product. So we have the agency promoting a published study and hiding the ball being what we need in order to test the study's conclusions.
I think want to push you just half a minute. The two scientists say we ran over 100 models. We picked the best 4. Those are the 4 that we think best support our conclusions.
Yes. That's what they're saying. And we wonder whether what they consider their best scenarios are the scenarios that essentially condemn this product, refined tar sealant. They're
not worthy of any credence.
Well, I'm not going to say that they're not worthy of credence, but I'm sorry, Your Honor.
They say these are the best, and the argument is maybe they're not the best. Maybe these scientists are no good.
Well, we're certainly not going to say that, Your Honor, but what they
aren't any good. I just want to understand what it is that we're after. That's all.
What we are after, Your Honor, is the ability to see how the outcomes of those other 200 modeling runs differ.
That's right.
From the outcomes of these 4 scenarios.
And so, as Judge Millett asked you at the beginning, your own scientists could do all this, and presumably that most scientists who would approach this question would approach it in similar ways.
We can only do that, Your Honor, with the 200 modeling runs.
So that's one way you could do it.
Pardon, Your Honor?
That's one way you could do it.
I believe it's the only way.
No, it's not the only way. You could do 1,000 models. I mean, I realize we're talking about money here. All right? And setting up a whole chemistry lab.
Yes, yes.
This.
Yes.
I just want to understand what it is we think that in a normal situation, the deliberative process would cover. You're saying all the work you do, and you may be right, all the work that is done in reaching your conclusion means that if you're on the government payroll, you've got to turn it over.
And if you work for a corporation or for a university, there'd be no question that you would have to make these 200 modeling runs available. But USGS wants its scientists to have a privilege, if you will, that no other scientists have. And again, what do we do with tens of thousands of pages of raw laboratory data? We can, yes, you're right, Your Honor, but we could come up with some modeling runs but we don't know whether they would be the 200 modeling runs that the study authors ran.
So let's suppose that the agency that we were dealing with was an agency like the EPA, and what these scientists had done was developed a model that was used to ultimately promulgate a regulation by the EPA to regulate or restrict or ban in some way these pavement coatings, and you submitted a FOIA request. So there's kind of would the model runs be covered by the deliberative process privilege there?
No, they would not, because the model runs are simply factual data. What are the inputs? What are the outputs? And
so it doesn't turn on whether the agency is a policy making agency or not. You're just saying that this is science, and so deliberative process of these scientists is not covered by the privilege, or you're saying that the model runs themselves don't reveal the deliberative process? I'm trying to understand.
I'm saying the former, Your Honor, that the scientist's thinking is not covered by the deliberative process privilege. And to use the words, again, we could cite a number of cases, but I think American Radio Relay is close. It says, quote, purely factual investigative matters, close quote, are not protected. The privilege is designed to protect processes by which agencies' policies are formulated and recommended. Now, USGS doesn't establish policies, but it's done the next best thing.
Well, we were talking about my EPA hypothetical, and I mean, doesn't your own briefing? I mean, part of your own briefing is that the data is not helpful because we need to know kind of like which data they selected and which models they ran. So disclosing that discloses their thinking. This isn't just data, it's disclosing choices that those scientists made, right?
That is exactly correct, but we submit that that type of scientific thinking is not the type of deliberation that is intended to be covered by a narrow privilege that goes to the formulation and recommendation of agency policies. And the result of the rule or the interpretation that the government is advocating is to envelop the entire scientific method, all that scientific thinking at EPA and every other federal.
What is your best case or cases for that proposition? American Radio Relay?
I think that's one very good case, yes. National Home Builders is another one.
All right, thank you.
Thank you.
We'll take the case under advisement.
Thank you, Your Honors.
There's Chris.
Case number 20-1049, Michael K. McNary, petitioner, versus Federal Mine Safety and Health Review Commission, et al. Mr. Ockard for the petitioner, Mr. Bacon for the respondents.
Morning.
Good morning, Judge. May it please the court, Mr. Bacon. My name is Tony Opegard. I'm attorney for Michael K. McNary, and with me in the virtual courtroom is my co-counsel, Wes Addington. I wanted to start with the issue that the court raised in its order on Friday evening, whether this dispute presents a live case or controversy within the meaning of Article 3 of the U.S. Constitution, including specifically whether McNary's asserted injuries are redressable by the remedies he seeks. And the court cited El Paso Natural Gas Company versus FERC. And we've read that decision. And we do believe that Mr. McNary has standing in this case, that he has suffered an injury in fact that would be the threats made against him, and that his injury is redressable by the remedies he seeks. And the court also cited the joint appendix at pages 11-13 and 117. And at the beginning of the trial on August 15th, 2017, the ALJ asked us what remedies we were seeking in the case, and that's set forth in the back and forth between counsel and the court, in which we said that one of the remedies is a fine. The purpose of the Mine Act is to protect the health and safety of miners, and civil money penalties are intended to incentivize the mine operator to comply with the law or disincentivize the operator from violating the law. And this is a 105c3 case. That is, the miner filed his complaint with MSHA. MSHA investigated and declined to prosecute the case. If they had prosecuted, it would be under 105c2. But the Mine Act gives the miner his own right to file his case if MSHA turns it down. And the statute provides, the Mine Act provides, that there has to be a fine for any violation of the act. And that would include discrimination or interference, findings of discrimination or interference. So typically, if the Secretary of Labor files a case on behalf of a miner, and if the ALJ rules that the law was violated, then there's a civil penalty attached. That's actually assessed before the case goes to trial. And the judge has to consider various factors, gravity, negligence, et cetera, in assessing a civil penalty. Under a C3 case, as Mr. McNary has, if we were to prevail in front of the ALJ, then that case would be referred to the Secretary of Labor for an assessment of a civil penalty. We can't assess the civil penalty. It has to be the government. So there would...
Is that civil penalty paid to your client or to the U.S. Treasury?
To the U.S. Treasury.
And the ALJ said at the beginning of the hearing that this plant is no longer producing alumina, and we know it was down to pretty skeletal crew. Can you tell us, at the time you filed your petition for review in this court, was the plant producing alumina? Was the plant operating?
I am looking right now to see, Judge, the date of when we filed the petition for review. And if you bear with me for a second, I should be able to get that. Petition for review was filed February 21 of this year.
As of February, tell me about the status of the plant and whether Mr. McNary is working there. I assume he's still not working there.
No, he was laid off at that point. He was laid off in, I believe it was 2016. Because this issue was not raised below, either before the ALJ or the commission or by Alcoa before this court, there hasn't been any fact finding on it. And I'm going on what my client has told me.
When you file a petition for review, you have the burden of establishing ending in a live controversy. That's just part of your job as a petitioner for review. So if you can just explain to us, so Mr. McNary is still not working there. As of February, my understanding this plant is getting closed down, but as of February, is this plant still open?
My understanding was as of February, yes, it was open. There was,
because it wasn't producing alumina at the time of the ALJ decision.
well, there's a difference, Judge, between a plant being open and whether it's in production.
Yes, and I'm asking whether it was producing alumina, which creates the very risk you seek to remedy here.
I don't believe it was, but I don't believe it was. I think it was a maintenance crew comprised of management, some hourly workers and some contractors, and there still would have been miners reps there. There still would be dangers present, even if it's maintenance. And that's my understanding.
If they're not, Mr. McNary, you said was laid off. Was he still going to the plant as a miner's representative?
No, he's not, Judge. I believe from what we learned from our client this weekend that the plant is actually shuttered now, and that there is not a maintenance crew at the plant now. It's really is closed down as opposed to being a skeleton crew.
All right. When you say there was a maintenance crew there, but it wasn't, nothing was being produced at the plant that you're aware of.
I believe that's correct. So a maintenance crew would be to, Mr. Bacon could probably answer this better than I, but to make sure that everything was in working order in case it was brought back into production, to make sure there weren't safety hazards present for those who were there. I'm not sure what the contractors would be doing and the hourly employees, if they were all maintenance. It's a rather large plant. You can sort of get an idea from the photos or in the record, like how big the valves are, how big the pumps are, and that's just a minor part of the overall plant. It's a very large operation.
You mentioned for remedies, you mentioned the fine, the civil penalty. What other remedies, at least at the petition for review stage, is your client seeking?
Well, if there was a finding that Alcoa had violated 105C, we had asked the judge for training to be required in miners' rights, specifically in the rights of representatives of miners for all management personnel at Alcoa. We had asked that the decision be posted, sort of like decisions are posted through the NLRB. Posting is a standard remedy in 105C cases. It has been for decades. And cease and desist order, which would ask that or order Alcoa to stop threatening miners reps who raise safety issues with management. And again, those are remedies that are regularly ordered by ALJs. So those are the remedies we seek, and the fine, the training, the posting, the cease and desist. And one of the things I'd like to point out, Your Honor, is that in 105C cases involving miners reps, unless the miner rep has been discharged, they typically do not involve claims for monetary relief. And the remedies that Mr. McNary is seeking before this court on this appeal are the same as the remedies that he was seeking on the day of the trial back in August 2017. We believe it's very important to protect representative of miners from discrimination or interference. Congress created that position to ensure that miners play a role in their own health and safety at the mine. And Congress also specifically stated in the legislative history of the act that Section 105C protects miners and miners reps against even subtle forms of discrimination, such as threats of reprisal. So it was recognized by Congress from the beginning that you would have cases where there is no monetary relief. The Mine Act is a make-whole remedy, or 105C is a make-whole remedy. The most a miner can get if he's been fired, he or she's been fired, is reinstatement to their job with back pay and interest. There's no punitive damages. There's no damages for emotional distress. It's a make-whole remedy. And typically in cases involving miners representatives, there will be no monetary relief. So our request really hasn't changed, Judge. When we read the El Paso case, it cited the Supreme Court case of Lujan versus Defenders of Wildlife. And in that case, Justice Scalia said that there are 3 elements necessary to confer constitutional standing. And that is injury in fact, the same thing that El Paso says, which he said is a violation of a legally protected interest, which is concrete and particularized. In other words, it's not speculative and it's not hypothetical. Number 2 is a causal connection between the injury and the conduct complained of, which we have here. We have a threat, that's the injury. And number 3, it must be likely as opposed to speculative that the injury will be addressed by a favorable decision. And we believe under Lujan, we also have all 3 elements necessary for a constitutional standing. And we believe that under El Paso, we have the same. We've met the requirements, particularly that it's not speculative. We're not saying something could happen down the road. We're saying Mr. McNary was threatened. He was threatened 3 times, and that is a concrete injury. And we believe it is redressable by the court. If I can turn to the merits of the case, a couple of points we wanted to make is first that MSHA issued 2 citations or orders to Alcoa the day after the incident between Mr. McNary and Mr. Emig on January 8, 2014. And in the order that MSHA issued, they specifically mentioned Mr. Emig, said that safe access to the pumps where they were trying to reseat the valve had not been provided. And Mr. Emig had engaged in aggravated conduct in failing to provide safe access. And although McNary had complained to Mr. Emig about sending workers into that area, or at the least allowing them to go into that area, the judge found that that wasn't protected activity, which really turns case law of 105 on its head over the years. And the second citation was that Alcoa failed to properly train the miners in the event that the pump valve failed. So the judge found that these citations were not material, that they were immaterial to the case, as if he was viewing them in a vacuum, where MSHA, here you have neutral arbiters, they're inspectors going to the mine to protect the health and safety of miners. They essentially agreed with Mr. McNary's complaints to Mr. Emig that you're acting recklessly in sending these miners into a dangerous area. And the judge also found it irrelevant in his analysis that miners had been burned at this plant before. The same thing that Mr. McNary was complaining about that day, he had been burned by that same slurry a couple of years before. And he was burned over 30% of his body. He spent time in a burn center a month, and he was off of work for about a year. But even closer to the incident, just 4 months before the incident in question, back in September of 2013, another miner, Mike Brown, was burned again in the digestion unit. And he was burned over 60% of his body and spent a considerable period of time in a burn center. Mr. McNary.
The inspector even referenced those prior incidents when he was having his vigorous discussion with Mr. Emig. Am I right?
He did mention the Brown incident. He said, "What are you guys doing? You had a guy who was just seriously burned a few months ago." And he pointed to the miners wearing the Ty-Chem suits and said, "Those are the guys you should be concerned about, not producing more alumina." And another issue, Your Honors, is that I'm sorry, I lost my train of thought here. Well, the court found that Mr. McNary had not been threatened because he was a minors rep or in his status as a minors rep, that he had been threatened in his status as an employee. However, when Mr. Emig was asked about that on cross-examination, he could not identify a single thing that Mr. McNary had done or any conduct he had engaged in or supposedly was insubordinate, other than the fact that Mr. McNary supposedly told him there'll be a group of people coming to assess the situation. That's all Mr. Emig could identify.
No, Mr. Emig also said that Mr. McNary had said, you can't tell me what to do, or words to that effect, at least in my capacity as a minors.
I don't have to listen to you, was his testimony.
So that seemed to be what the ALJ was focused on. So talk to me about what we should do about that, given our definition of ALJs.
Yes, Your Honor. First of all, the ALJ had several variations of what Mr. McNary had supposedly said. He didn't just confine it to, I don't have to listen to you. And certainly Alcoa in their brief has not confined it to, I don't have to listen to you. But our position is that a minors rep does not have to listen to a supervisor's evaluation of a danger. And that goes back to the DC Circuit's decision in the Phillips case, which was one of the seminal cases under 105C, where the court said it's clear beyond peradventure that a minor does not have to accept a foreman's evaluation of a safety danger. That's the whole purpose of a minors rep. Mr. McNary was representing other minors at the plant. He's supposed to raise issues having to do with safety and health with supervisors. Also has the right to travel with MSHA inspectors. So when he tells Mr. Emig that you shouldn't have sent the minors into that situation, and I've called the health and safety manager, she should be on her way to help assess the situation. That's when it escalated. And there's dispute between what Mr. Emig said and McNary, but really when you compare the testimony, they're not that different. Mr. Emig basically said, I call the shots, I make the decisions, not you. And when Ms. Gronis, the health and safety manager, came to the site, then Mr. McNary was not involved in conversations with her. He was standing to the side by that point. But our belief is that he has that right to say, you shouldn't have sent workers into this area. He has the right to call a supervisor to come to help with the situation, to help protect those minors. And another critical point is that Mr. Emig admitted in his testimony that he knew Mr. McNary was concerned for the safety of the minors. He wasn't questioning that. The court also, the ALJ also found, and we believe this violates the case law under 105C, that because Mr. McNary did not invoke this quote unquote stop job policy, that stripped him of the protection of 105C. And the stop job policy was supposedly any minor at the site had the unfettered right to shut down the operation if they thought something was unsafe. And there was testimony about that at the trial. And curiously, the judge found that because Mr. McNary just complained about the hazardous conditions, but didn't invoke the stop job policy, that somehow he loses the protection of the act, almost as if the judge was questioning his good faith, although he didn't come right out and say that. And the interesting thing about that stop job policy, though, is there was testimony that after Mr. McNary and Mr. Emig had their argument, Mr. McNary was standing to the side. At that point, there was conversation between Mr. Emig, Carlos Delgado, who was the lead miners rep at the mine, Kelly Gronis, the health and safety manager who had showed up, and Brett Barrick, the MSHA inspector. And the four of them were discussing. And Mr. Delgado basically said what Mr. McNary had said: you're not sending anybody else back into that dangerous area. Now, according to the judge, supposedly Mr. Emig was very respectful of Delgado's opinion, and it didn't get heated, but that contradicts Carlos Delgado's testimony. He said it got heated. Mr. Emig didn't like to be contradicted. He was the boss and he wanted to run the show. And when Delgado said to him, you're not sending somebody back into that area, i.e., to me, that's a stop job policy, Emig flatly ruled that out and said, we have to access that valve. The only way we can do it is sending people in there. I'm not shutting down the plant. Now, whether or not there's issues, involving safety about shutting down the plant, it is sort of beside the point. Mr. Delgado was saying you're not going to send anybody in there, i.e. you're going to shut down the plant. And that was rejected by Mr. Emig out of hand. But nonetheless, the judge found because Mr. McNary did not try to shut down the plant that he lost the protection of 105C.
All right, so these are arguments as to why abuse of discretion or clear error, correct?
Correct.
All right, so why don't we hear from counsel for Bond?
Thank you, Judge.
May it please the court, Mr. Elpergard, I'm Christopher Bacon and I represent Alcoa. I'd like to begin with the issue about the jurisdictional issue that the court raised in its order on Friday afternoon. When this case was tried in 2017, I think it was in a very different posture because the Alcoa plant had temporarily closed down, but at the time, I think there was an expectation or a hope that at some point, the price of bauxite would be such where they could start up again. And that would probably, I think at that point, there was probably even a potential for Mr. McNary himself to be recalled under his union contract. Throughout 2017, 2018, and 2019, there was a skeleton crew, and the case, the plant continued to be under the jurisdiction of MSHA. And so MSHA, because one of the things that MSHA has to do when you have a surface mine, they would still come in and do their twice a year wall-to-wall inspections. Occasionally, they would even issue citations. So there certainly was a reason that if this case, if they were still in that posture of the possibility of reopening again, I think it certainly made sense to say, at some point, there could be a remedy for Mr. McNary. In December of 2019, Alcoa announced that it was permanently shutting down the facility and that they would not reopen the facility again. And in January, shortly before this petition was filed, MSHA deactivated this mine and informed Alcoa that it was no longer going to be under MSHA's jurisdiction and that going forward, they would be under the jurisdiction of OSHA. And you can actually, if you were to go to MSHA's website, you wouldn't find the Alcoa Point Comfort facility listed. All existing active mines in the country are listed on the MSHA website. And at least since January of this year, the Alcoa facility has not been an MSHA facility. So in the event that, this case were to be sent back at this point, I don't believe that MSHA would have the jurisdiction to come in, for example, and post a notice. And if anybody was going to be training anybody, if anybody was going to be carrying this, doing any safety work, it would be OSHA and not MSHA. So I do think that today there really is a question as to whether this court really would have jurisdiction over this case. I'm not sure that was the case back in 2017.
Yeah, well, Article 3 doesn't apply to agencies. So is the plant still open now?
My understanding is that they're trying to sell the plant, so there are some people there, but the plant is closed.
Not functioning. It's not producing.
The plant has not been producing since 2016, and it was not producing at the time that this case was tried. But at the time, it was temporarily shuttered, and so there was a crew of probably 100 people doing maintenance and things like that.
The statement by MSHA in January of this year that it was deactivating the mine that was no longer going to be under its jurisdiction. Is that a public statement, a record, or something that document that you could send to us?
No, they actually never did. They verbally communicated that to Alcoa, and then they removed Alcoa from the MSHA website. But they were simply informed by the inspectors from the San Antonio office that typically inspected that plant that they were no longer going to be inspecting that plant, and it was no longer going to be an MSHA covered plant. So it was simply a verbal communication. And the only proof of it is that it was removed from the website.
The person to whom that verbal communication was made, someone who could submit a declaration to that effect?
That person could do that, yes. That's the current plant manager who's overseeing the plant at this point, yes.
Okay. Okay, and that was, you said January of 2020, so before the petition for review was filed.
That is correct.
All right.
And then may I briefly address the merits time that is remaining? As we pointed out in our brief, there really is, and there was a difference in version of events from Mr. Emmig's perspective and from Mr. McNary's perspective. The judge, the ALJ in this case, believed Mr. Emig, and he didn't just simply say, I find Mr. Emig credible and I did not find Mr. McNary credible. He actually offered an analysis as to why he reached those credibility determinations.
What substantial evidence, I need substantial evidence, is there to support the proposition that Mr. McNary went from being concerned about the miners, as the ALJ specifically found, to usually wanting to have some kind of power coup and take over handling of the crisis? What substantial evidence is there? All I see the ALJ citing is that exchange where he said, you can't tell me what to do. And they said, what, as an employer or as a miners rep? And he said, as a miners rep. All right, so what substantial evidence is there? It strikes me as crazy to think that.
I think there was two facts, though. I think the first one is which Mr. McNary did not admit to, but which Mr. Emig testified and the court believed, which was Mr. Emig got upset because Mr. McNary says, I do not have to listen to you. I do not have to listen to you in my capacity as the MSHA rep. Mr. Emig said, yes, you do. He said, no, I don't.
But he doesn't have the MSHA rep. You would agree that he doesn't have to listen to him in his capacity. He's not his supervisor as a MSHA rep. You agree with that?
Not as an MSHA rep. But
okay.
But another fact that Mr. Emig testified, and also Mr. McNary admitted upon cross-examination, is after he was asked by Mr. Delgado to step aside, and Mr. Delgado and Mr. Emig and the MSHA inspector were talking about what was the best strategy to contain this crisis, Mr. McNary came back and inserted himself in that conversation and said, he started to complain about being sent on a wild goose chase. Here again, he was.
That was a complaint about what was happening with the miners being sent in or allowed to go in, but being dressed up by Mr. Emig to go in. Mr. Emig was dressing them up looking for duct tape. All right. To go in. All right. To send them to at least as a supervisor to allow them to go in there. I don't see any evidence of that's insubordination. That's this very protected activity. I don't know how that's not protected activity.
Well, I think
the miners rep, you can come in and go, look here, I don't know what he's telling you now, but here's what happened. He was wanting to send miners dressed to go in there.
Well, I think the ALJ looked at it all, I think, sort of, again, in the totality of the circumstances.
This ALJ must have had like a function where he could say totality of the circumstances as many times as he wanted in that opinion. But this opinion, I don't see any substantial evidence for concluding that Mr. McNary, who was engaged in protected activity in contacting Ms. Groan, who Ms. Groan said it was appropriate for him to contact her, who was concerned about minors either being sent in or allowed to go in. MSHA itself found that Mr. Emig was violating safety rules and how he handled this situation and put minors at risk. And then he comes in and whatever led to this statement that I'm not going to do what you say as a minors rep, that's not insubordination. I see no evidence of insubordination other than this ALJ saying, and trying to invoke these sort of magic words, and clear error is a very hard standard. Abuse of discretion is a very hard standard, but it doesn't mean that we close our eyes to reality. And there's nothing to support insubordination in this record.
Of course, in an interference case, the question before the ALJ is or did what Mr. Emig did end up chilling his right or his desire to later make complaints? And I think that, the fact that Mr. McNary was still, even after he had been, asked to step aside, was still extremely confident to come in and interfere in the discussion. Was never.
Where do you get that adjective? He thinks he's just been told he's going to be removed as a minor's rep. He's going to be removed from the whole workplace. That's not confident. He's worried. He's upset and worried. And the ALJ was very solicitous of Mr. Emig being upset in this situation. But this seems to me exactly in the heat of the moment when minor safety is at risk, when the MSHR representative is upset and yelling, when Mr. Delgado is upset and debating. This is exactly the time when you want minors to step up. This is exactly. I'm worried about the proposition here that in the heat of an acute safety crisis, it's okay for supervisors to make serious threats against protected activity like they did, because it was a stressful situation for the supervisor. But that seemed to be the ALJ's rationale, that Mr. McNary should have said, I see you're under a lot of stress. Let me just go over here and be quiet. But,
Mr. McNary, shortly after this, this was, again, something that occurred in a matter of minutes, a very high stress situation.
Yes, why doesn't that count in favor of?
And Mr. Emig himself admitted that he lost his temper inappropriately, and he did testify to that. But within a matter of a short period of time. I'm sorry.
1 second. He admitted he made those threats.
Yeah, he admitted made those comments, and I think my recollection in his testimony, he wasn't proud that he had made those threats, but in a matter of moments, Mr. McNary was part of the post-accident investigation. He went back and wrote down his statement. He was part of the investigation, the post-accident investigation. The fact that somebody.
How did he know he wasn't going to get fired?
Well,
maybe they're not going to do it while the MSHA inspector is there on premises. But how did he know he wasn't at that moment? How did he know?
He certainly didn't act like someone who.
Well, what is that? No, that's exactly what we rejected in Wilson.
Yeah, but in this particular case, he definitely showed confidence to keep on asserting his.
Rejected in Wilson.
Yeah, I think that in this
a reasonable minor or minor rep, we'll just say a reasonable minor who's trying to raise safety concerns in the heat of a crisis and is told by someone who's not, as you said, not proud of what he did, that you're going to be fired, you're going to be removed from this plant, removed from your position, right when we most need safety voices to be loud. Tell me again how that is insubordinate.
Well, I think that he was primarily focusing on his. He turned this into a power struggle at a time.
A power struggle. That's what he had to do because Mr. Emig was allowing people to go in. If that's what you mean by power, I'm really thinking about future cases, how we could possibly write an opinion that would say it's okay for a supervisor to make the ultimate threat against an employee in the heat of a safety crisis because that person raised safety concerns, engaged in protected activity, and said you can't tell me not to do that, can't tell me what to do as a minor rep. We're going to have a heat of the moment exception.
Well, I think what you have to do in that particular case is evaluate how long this took place, what happened immediately before, what happened immediately afterwards. The fact is, in every workplace, mines and any other type of workplace, people sometimes lose their cool. People sometimes say something inappropriate. And so the question becomes, does this have an enduring effect on the people that are there.
Is enduring effect a factor for interference?
I think it's how would a reasonable miner react to this? I mean, this was someone who, the testimony from Mr. Delgado admitted that, this was a company which actually the safety manager, the plant manager they were all very accessible to the miners' reps. The miners' reps frequently engaged in very robust discussions, over safety issues with the miners' reps. These people were comfortable speaking their mind.
Mr. Emig shouldn't have gotten upset that he had someone contact Ms. Grones.
Well, but see, that's what the judge did not believe. The judge did. First of all, Mr. Emig's testimony was he had already contacted Ms. Grones and she was on the way.
I understand that, which is all the more right. I understand. That doesn't mean in the ALJ's power play theory here. The whole theory was that he was upset that Mr. McNary had done it and was trying to bring people in to consult on the process.
Well, part of Mr. McNary's problem was that the judge actually did not believe he was being completely truthful about what happened. And if someone is not being truthful when they're testifying under oath,
they said I credit Mr. Emig's version of events, but Mr. Emig's version was that you can't tell me what to do, and they clarified as a miner's rep.
He also did not believe his testimony about the affidavits that he produced, and the testimony is Mr. Emig's testimony was distinct from Mr. McNary. They told a different story. Mr. McNary. Mr. Emig did not say he got upset because
I credit Mr. Emig's testimony. I still see no substantial evidence of insubordination. I'm having trouble identifying it, and I'm very worried about this. The ALJ's reasoning that it's the heat of a safety crisis. That's when we let supervisors explode with threats of termination. That somehow that's what the act allows.
But there again, you're looking at a very short period of time. And is that going to have a long-term deterrent effect, what happened in just a short period of time?
Well, firing only takes a second.
Mm-hmm. But he never was fired. He was never even he never even left the area.
Mm-hmm. Right, that may well go to your discrimination claim, but I'm talking about interference.
Well, there's not a discrimination claim because there wasn't an adverse employment action, but I think you do have to, otherwise, just any outburst will support an interference claim. And I think you have to look at outburst, even inappropriate outburst, in the context.
Any outburst. This was not just any outburst. Mm-hmm. He was, even by the ALJ's version of events, upset that higher management had been called in to assess the situation, and that he had said, I don't have to do what you tell me to do as miner's rep. That's not just any out. And he was so upset, stressed out, that he threatened him with termination. That's not just any outburst. Let's be clear here. All right, that's not just any outburst. That is absent characterization as insubordination. That is a signature violation of the rights to engage in protected activity. It's only by trying to recharacterize everything as the ALJ did of insubordination, that's what's critical, as far as I'm concerned, that you're able to say that's anything other than the poster child for retaliation for protected activity. And so that's why I keep asking about what other evidence there was to support insubordination. But I don't mean to beat a dead horse here. I think I understand your answer at this point.
All right, anything further?
No, does the court want us to submit an affidavit from the plant manager regarding the closure?
I would like to see it if it's okay with my colleagues.
Fine. Good. All right, fine. Thank you.
Fine with me.
All right. So, all right, counsel for petitioner, anything further?
Yes, Judge, we'd like to make 3 quick points if we could. Number one, on the merits of the case, Mr. Bacon said that Mr. McNary had reinserted himself back into the conversation. This is when he said he just threatened me, speaking of Emig. We just want to point out that if he in fact reinserted himself, it was already after Mr. Emig had threatened him, had committed the violation in our view of 105C. In our brief, our initial brief on page 16, footnote 16, we said that we cited the case of Secretary of Labor on behalf of Dunmire and Estill versus Northern Coal Company, where the commission said that the key to evaluating communication issues between management and miners is what the plain meaning of the words would convey to any reasonable miner. I should have cited another case there if the court would allow me to cite it now. There is a case, Secretary of Labor on behalf of Gray versus North Star Mining and Brummett, 21 FMSHRC 1, 2005 case. And in that case, the commission said that when there's communication, if there's a threat from a supervisor to a miner, the issue is not what the supervisor intended, but how it was perceived by the miner. That's what the court has to look at. The final point I wanted to make, going to the issue about standing, is that
That's 21 FMSH. What?
27 FMSHRC 1, page 1, 2005.
Thank you. And the third point?
And the third point was going back to the standing issue. Posting might be difficult at this point because if the plant is shut down, but we do believe that posting, Alcoa World Alumina still exists. Of course, we just looking at Dun & Bradstreet, they said that they have about 1,000 employees at this time, expected sales in 2020 of $1 billion. And I believe the number was 132 associated companies in their corporate family. And we believe that a cease and desist order and a training order could go to management of Alcoa, not just people at this plant. Also, Mr. Emig could be ordered to undergo management training. I don't know, and Mr. Bacon may, whether or not he is still employed by Alcoa World Alumina. The point I'm making is that Alcoa World Alumina still exists, even if the plant, the Point Comfort plant, where Mr. McNary worked, is shut down.
All right, fine. We will take the case under advisement. Thank you very much, counsel.
Thank you, Your Honors.
This honorable court is now adjourned until Wednesday, December 16th at 9:30 a.m.